Thank you for joining. I am covering this YSL trial through the end, y'all. I'm committed. I'm hooked. I can't stop. We get started a little later than usual on here to kind of get past the breaks and all the hiccups that go on in trial. And on top of that, it's a small channel. So we just kind of chop it, our comments, learning as we going, really good discussions. And I love for you to join me. So come on in. And without further ado, we are going to get started. I mean, I'm watching this trial. I might as well stream it and keep building my channel. Let's keep going.
I think we can move to our set of next 30 witnesses and start going through that evidence. Oh, and sorry, let me circle back. I'm looking at my notes from yesterday. Mr. Harvey, you wanted to raise something about item number 74 with Dennis. We were going to look at the CAD reports also, so we can do both of those things before we get to the next grouping of witnesses.
That's correct, Judge, and we were waiting to see the court's order. The court's order dealt with essentially the admission of lyrics. Our challenge to, it's number 26, Dennis, item number 74, right?
Did the state find that order? Okay.
Your Honor, we sent that order last night to court and all parties. Judge Glanville's ruling on the lyrics.
Okay. I didn't see it in my email this morning, but maybe it's there now.
But would it be a fair characterization to say that it's the admission of the lyrics, and the court ruled on the admission of the lyrics? This is a video, and it is a video essentially with one of our co-defendants as the primary singer. And I believe it has Mr. Nichols in the background. So my challenge is not to the admission of the lyrics,
Okay.
but to the admission of the video. And I think the video should be admitted against, with all due respect, Mr. Jackson, but not admitted against Mr. Nichols. It's Mr. Jackson's video and Mr. Nichols is in the background. And that would be like saying, if Gladys Knight and the Pips were singing, it would be admitting the actions of the Pips against Gladys Knight and that midnight train to Georgia. Not that I remember
Who's
that
who
song.
here? Jackson is Gladys and Nichols are the Pips.
The Pips, yes. Mr. Nichols is a Pip.
Okay. Well, I mean, I guess I don't know, let me look at the video, but I would think that both Mr. Nichols and the Pips are in the background voluntarily.
Before you look at the video, can I just make an observation and a comment? My client's artistic expression, I want to put this in context. My client was arrested in 2005. The state has, not until 2022, I guess, got around to trying this case.
Uh-huh.
Mr. Stillwell was rapping, and he dared to say in his rap song, "I beat a murder rap, paid my lawyer 30 for that," because a reasonable person would believe that he had been arrested for murder and beat it because he had been released and no one had tried him. I have no idea how this has become some sort of admission saying I beat a murder rap, because he was arrested for murder and he did beat it. I have no idea the relevance of this. He's just stating I've been arrested for murder, which is clearly true. And he beat it because he was out on bond. So I have no idea why this is admissible against anyone. I have no idea why it's relevant. I agree with Mr. Harvey that the fact that Mr. Nichols is in the background shouldn't come in either, but I don't believe that this should come in against my client. I think that this whole ruling is out of left field, respectfully, and that's our stance on it. I just wanted to provide that context before you viewed the video, because that's what it is. It's years after he had been arrested for murder.
When's the video from?
I don't
2019, we believe.
2019. So it's 4 years. The state says 2019. I'm not certain, but according to the state, it's 4 years after he had been arrested. He had been released, and no one had tried him on the murder, which he's innocent of. And he was merely stating, I beat a murder rap. So I don't know why any of this is coming in, but I appreciate Mr. Harvey's point that nothing came out of his client's mouth either.
Yeah, it's not an assertion under 801 D2E. So I don't see it coming in with regard to Mr. Nichols. And I adopt everything that Mr. Shart just said as well.
Interest either, Your Honor. It's not against any interest. It's not anything that's inculpatory.
Talk into the mic because they can't hear you back there.
Good morning, Judge.
Good morning.
I'm not sure that it's against any interest. It's not anything that's inculpatory.
I think that might just be a statement by a party opponent.
All
Your
right,
Honor.
but my client made no assertion.
No, I'm talking about as to Mr. Jackson himself.
Your Honor, I would point the court's attention as well in response to Mr. Nichols' assertion to page 8 and 9 of the order.
Okay, I still don't have the order in front of me, so
Send it to.
Your Honor, I would resend it. It was sent at 4:47.
okay.
Yesterday. I will resend it right now.
I mean, I thought I perused it.
Pay my lawyer 30 for that. And my slimes of butter.
But it appears. that- Is it on Zoom? Okay, let me get on Zoom. All right, go ahead.
Trying to rob him for something. And I keep it stupid. Ain't no void no smoke. Drop top coupe. Looking for who? Let it bang when you do. That's safe for you. Get you flipped in this shit, I'm on road day, yo. I'm that slime they always talk about. cash, they never touching them. I just beat a murder up. Pay my lawyer 30 for that. Then my slimes a brother law. Ain't why you no clear. Tonight we open the door. Yeah, y'all need wait for these bodies off. And I wipe your nose, sit in your family face, and just slide it off.
All right, I don't see any reason to revisit the ruling.
Well, it wasn't,
With regard to the, so if we don't show the video, then I mean, the state intends for it to come in as against everybody. And there's no way for it to do that if the jury doesn't see everybody in the background.
well, if it comes in, I don't think it should come in against Mr. Nichols. It should come in against Mr. Stillwell. And I would again ask for a 105 instruction with regard to this. It is again, Mr. Nichols is just a person in the background.
Who chose to be in the background. So y'all can argue the same thing you've argued to me, which is, okay, all this is a song. But the state can argue what it wants to argue. The ruling, I don't see, again, any reason to revisit that. And with regard to the video itself, it would be the same rulings. Okay. So how about the CAD calls? Or not CAD calls, CAD reports. So I think we found these in what folder do we need to look to for these?
Witness 19, Sharon Latner's, Your Honor, in the 8 August 24, 1 through 30.
Okay, thank you. All right, do any of the defendants want to make a hearsay or other objection to any of these CAD reports or portions of CAD reports? Sure. Yes.
All right, so, and I'm really what I'm doing is repeating an objection that we've made previously. Ms. Latner has testified numerous times before. She's come in regards to various 911 calls that have been made. And our objection has been and continues to be objecting to any hearsay that would be contained in.
Right, so point out for me now the hearsay so that we can make a ruling on that.
All right, so we're probably gonna have to go through them one by one. And if
That's fine.
with the court's permission, if I may retake my seat and kind of.
All right.
Under the Latner's file, the first CAD report, when you open it, it says page 4 of, I'm sorry, 1JJ CAD report at the top.
Yeah, it says that on the,
It's
yeah,
printed date is 6/22/2022. If that helps.
yes,
All right. And so I'm going to go to page 4
okay.
of that, page 404, where there's a statement um, under CAD narrative. Under remarks says number 78, shots on call, 6 to 7 vehicles shot up at location. My position is that that's going to be, I don't know who the,
Talk into your mic a little bit better if you can.
a little closer. Is that any better?
Yeah,
All right. So my position is going to be that that's going to be a hearsay statement. We don't know where that information comes from, the accuracy of that information, who it is that's speaking, and so we would object to that coming in and ask that be taken out from that particular CAD report.
So, Your Honor, this is 1J is a self-initiated, it's an officer initiated. There's not a 911 call for this specific 1JJ, there is for 1JJA. And so this is received at the top on page 1, it's received at 2:20:41, so 2:20 in the morning. And 2517 Donald Lee Hollowell is Club Crucial. And if you look at what Mr. Adams just annotated, that first, there's no 78, which means there's no suspect. Shots on call, 6 to 7 vehicles shot up. There was 6 or 7 vehicles parked in the parking lot of Club Crucial shot up. And that time hack is 2:20:41. So when the officer initiated this CAD, the state views this specific one as essentially a present sense impression of the officer who's trying to get help. He's literally there. This is all from radio traffic, and the computer aided dispatch CAD gets generated. So he is in real time stating there's 6 or 7 vehicles that are shot up and to get officers to come. So the state feels that that hearsay exception to this is appropriate.
all right. I'm going to overrule the hearsay objection based on 803(1). What's next?
Your Honor, the second one is 1JJA.
All right.
At the bottom in the narrative, at 2:21:28 a.m., says heard about 30 shots. I'm not
State's-
sure who the declarant is.
All right, state's response. I mean, I think everybody's probably going to concede all of this is hearsay. It's just a question of whether there is an applicable exception.
Yes, Your Honor, and this comes from the 911 call that the state would also be playing. So this CAD report, unlike the one we just addressed, came from a citizen in a neighborhood like very close to Club Crucial. And she states on that 911 call, that's pretty brief, just heard, she says, heard about, she's on Woods Drive and she says, don't come to my address, but I just heard a lot of gunshots. I don't want to give my name. And so the state feels that, for one, her calling is an excited utterance from hearing gunshots in her neighborhood. And number two, this 911 call is very brief. She is not, there's not a confrontation clause with that statement because she's not making that call to prosecute someone. She doesn't even want to give her name nor know who did these gunshots in her neighborhood. So this CAD report is in conjunction with the 911 call that generated the CAD.
All right, that would come under the 803(1) and 2 exceptions, so I'll overrule that objection.
Judge, the next one, we're going to skip because I believe the third one down is actually an actual 911 call.
Okay.
So if we look at the fourth one down, which is 1KK CAD report,
Okay.
when you open it, it's more than just a CAD report, it's a police report. But
Is the state intending to put the police report in?
Your Honor, that was a typographical error, and I can actually publish, when I uploaded these documents to the Dropbox, I had a version where that was just a PDF and I removed everything to just include the single CAD. So for purposes of this, I meant to just, it's embedded in the 28-page PDF, but
Okay, you're just going to be using the CAD report part. of it.
correct. And specifically the CAD that ends in 455. But for time's sake, I don't want the court or defense to look through those 28 pages. I'm happy to
Appreciate it.
publish. Okay.
Go ahead.
I'm going to join the Zoom right now. Your Honor.
Okay.
Mr. Atkins, is that the CAD report that if I'm looking at 1KK that starts at page 14 of 38? Is that right?
I don't have the original PDF I got this from, but the CAD ends in 455 and it's a single page CAD report, if that helps.
Okay, I see, I see one that ends in 455. It looks like it's maybe on, it looks like it might be the last page 38 of 38 on what we're looking at.
I see it.
All right. And what's the objection?
All right, same here, sir. Objection. If you look at the bottom of the CAD report, there's going to be information by a declarant indicating call advised. You heard 8 shots fired in the area. That's the last line of the CAD report. My position is that that's not the officer reporting. That's simply the officer reporting what was reported, and so that would be hearsay. We'd object to that.
Your Honor, the 911 call that corresponds, there's multiple 911 calls for this incident. The caller advises he heard 8 shots in the neighborhood, and he states he does not want to speak with an officer. He again wants police to come to his house. I think it's about a minute or so. It's a short call. So the state's position is it's a excited utterance from the neighbor calling after he heard 8 gunshots.
All right. That would be an exception under 803, 1 and 2. What's next?
Your Honor, 1LL.
Okay.
It's in the narrative, it says heard 9 gunshots fired near parking deck
Okay.
at 5, and it, according to the CAD report, it's 5:52:18 a.m.
State's response.
Your Honor, that's so we've skipped for a second because there's other CAD and 911s for, so I'm switching to 1LL. Give me 1 second. Yeah, so this 911 call, the caller, so the incident happens at 1903 Drew Drive, and the 911 call that corresponds with 587, which is 1LL. She says, I just woke up and heard about 9 gunshots. It came from the parking deck. This is an apartment. She gives her phone number, the apartment, and the gate code so officers can get in. She does not see anyone. And then she says she does not have to speak with an officer, just heard a lot of gunshots. So the state's position, again, is excited utterance and not for the purposes of prosecution in terms of confrontation clause analysis, because that, my apologies, Madam Court Reporter, the heard 9 gunshots near parking deck is the CAD report automating what the 911 caller audio, which we have, states.
All right. That would also fall under the 803, 1 and 2 exceptions. What's next?
I think we're going to have to jump down a bit to what looks to be 2LL CAD report.
Okay.
I believe that ends in incident number 588.
Yeah.
It's a 3-page CAD report. On page 2 of 3, there is at 4/28/2015, 5:52, there's an annotation that caller advised she heard banging on her window. Nothing further, and then a line beneath that where it says there's actually a description. I'm unclear as to whether or not that is a description being relayed by the officer or a description that was given to the officer by a declarant that we don't know who it is, where it says 78C-BF, dark skin, head wrap, black shirt.
Okay. Mr. Atkins.
Yes, Your Honor. And with this CAD report, the state, you can get CAD reports in present time, but I don't have the 911 audio that accompanies this. So I can't state for the court, so the state can redact that specific line because
Okay.
I can't articulate
All right,
how that came about.
all right, y'all can go ahead and redact that then. What's next?
3KK, 4/28/2015 at 4:05 a.m. There's a note, do not see CLR. I believe that might be caller.
Yeah,
Caller heard multiple gunshots in the area. That appears to be a police officer after the fact relaying that they cannot find the caller who previously had stated
right.
that they heard multiple gunshots in the area. So that does not seem to fall under any
Yeah.
exception.
I agree.
And Your Honor, to be clear, are we talking about 3KK?
Yes,
Three
sir.
KK, yeah.
So this actually is a 911 call, and the caller advised they heard, we have that audio. The caller advised heard 8 shots fired in the area, they say someone is
Okay,
firing off
hang
AKs in the
on, hang on.
neighborhood.
So
Yes, Your Honor.
this is a one-page report, right? And we're down at the bottom, under the narrative, the third line at 4:05:20, do not see CLR heard multiple gunshots in the area. Can you address that?
Give me 1 second, Your Honor.
Sure.
I may have misnumbered my 3, maybe, let me see. Okay, my apologies. My numbers were 1 off.
It's okay.
There is a 911 call for this. It's
Mhm.
very hard to hear. The person's just, I can play it. It's only like a minute. But essentially, that 911 call that accompanies this, and it says source E911 call. He's saying that he hears shots. It's hard to make out the totality of what he states because he's just not speaking into the cell phone very clearly. But my understanding is that comes from his call.
All right, why don't we just listen to
Okay.
it?
Yes, Your Honor.
Atlanta 911, operator 2091. What is the address of your emergency? Okay, do you need the police, fire, ambulance service? You need the police?
Yes, it seemed like there's a time.
Okay, can you try to speak a little louder? We have a bad connection. I can barely hear you.
Can you hear me now?
It's a little bit better.
Okay, I'm saying that it seems like there's some type of time not for us to things going on in my neighborhood.
Okay, and you said you're at 1469 Mem Street. Do you want to meet with the police when they come out?
No, I just send them out.
Okay, how many shots did you hear?
It was like a whole round.
Okay, all right. We'll send the police out to check the area. Do you want to leave your name and number? Okay, Mr. Moore, verify the phone number you're calling from. 404-758-3914. All right, we'll send the police out to check, okay? Thank you.
All right, so the caller heard multiple gunshots seems to be something that the caller reports on the call, but do not see caller. I don't know where that comes from unless it's from.
Your Honor, I see what the court is stating. At 4:05, so the call comes in at 4:03:37, and because there's multiple 911 calls, there's already officers heading that way, and so this isn't the first call, and so a minute and 20 seconds later almost is an officer radioing, I do not see the caller. Caller heard multiple gunshots in the area, so I think they're just parroting back the 911 call.
Right.
I don't have any problem redacting that. I do view it as the officer's present sense impression, but I don't know why it reparrots the caller heard multiple gunshots, because obviously he didn't speak with someone because he says he can't find him. And that caller didn't want to come outside and speak. So I don't have any problem redacting that third line, Your Honor.
Okay. Thank you.
Yes, Your Honor.
What's next?
Yeah. All right. Your Honor, the next one is 4KK CAD report. It's second to the last entry. It is a two-page CAD report. On page 2 of the CAD report, towards the bottom under a CAD narrative, there is at 4/28/2015, 4:06:28 a.m. female shot. I concede I don't know what KFO8
Yeah.
means. Night commander copies female grazed by bullet. Caller stated someone shot up house. Looks like it says Supervisor Arnold and Denson, and I don't know what the rest means, but that's obviously, and it notates that there's a female caller. So this information is obviously not obviously, it appears to be being relayed by a female caller. We don't know who that declarant is, whether or not the caller is being offered for the truth of the matter asserted that someone shot up a house, and we don't actually know.
All right, maybe we just need to listen to this one.
Yes, Your Honor. And I think it is coming from the 911 call. I will play the 911 call for this one. It's a little bit longer. It's like 6 minutes.
Well, you can just get to the part of it that matters.
Yes, Your Honor.
Put that weed out. Okay. And that's the 911, operator 6587. What is the address of your emergency? Someone just turned a shot on my house and my auntie got shot. Okay. Okay, what's the address? 1428. 1428. Adair Avenue. Adair? 30314. Is this in a house or an apartment? You said what, ma'am? Is this a house or an apartment? A house. Okay, that's Adair Avenue Northeast? Southeast? I thought it's Southeast. Okay. 1420 Adair Avenue, and that's the 30314. Okay, it's not coming up Southeast.
And Your Honor, around 2 minutes and 31 seconds, this gets to the female being grazed, so I'm going to jump to that.
Okay.
All right, and what's your name? Dominique. Okay, Dominique, tell me what happened. I was just, when I woke up from sunshine, somebody just told me they were shooting up the house. Okay, was anyone shot? Yes, ma'am. Okay. Are you with the patient right now? She's lying in the bed. Okay. Are you with her right now? You said what, ma'am? Are you with her right now, Simon? Yes, ma'am. Okay, how old is she? She is. She didn't get the bullet didn't go through. She got straight. But she is. How you have this way?
And the reason I highlight that part, she says the bullet did not go straight, which is
Right.
how the CAD report ends up reflecting female grazed by bullet, because
Okay.
her aunt was shot.
Okay, I mean, other than the night commander copies part of that, that's all the caller obviously relaying what just happened. So that would fall under the same exceptions as the others. Do you intend to, I mean, the night commander copies part, can you
I can redact that, Your
redact
Honor.
that out? Okay,
Yes, Your Honor.
all right, what's next? Is there anything else?
I believe that's it.
Okay, all right. The other thing I had written down from yesterday was Mr. Stillwell jail calls, if y'all are ready on that. If not, we'll just move on to the next.
I'm ready, Your Honor, just thinking about the most logical way to address these issues. They're about 14, 15-minute calls. The state has, to my knowledge, not given any clear direction on what they plan to play. So I think that maybe it makes more sense for them to propose what is admissible,
Okay.
and then I can respond.
All right. And Miss Hilton, is this the one that you sent over that was like in a spreadsheet, or where would I go? What's the best way to go find these?
No, Your Honor, that was the co-conspirator statement.
Okay.
But in the same Dropbox, these are all in the Mike Sprinkle folder
Okay.
under Shannon Stillwell.
Okay.
Your Honor.
And Your Honor, it may do well for us to have a conversation at a break with Mr. Sharp and counsel, because there are some that we've identified that we will not use, and then there are redactions that we have.
All right. I was hoping you would have provided that information to them before now so that we could get right to what we still need to litigate.
As there were some that were excluded as late as last night, I can address them, some of
Okay.
them.
All right. Why don't we
Okay.
take such a break right now then?
All right.
Club Crucial shooting, which is
The information we've got to litigate. Relates to Mr. Stillwell and the information we've got to litigate.
Okay. Before we get to that, actually, with regard to the CAD reports that we just went over, how many different incidents does that cover?
Oh, how many? 10?
Let's ask Mr. Atkins, since he seemed to be handling
He
it.
was.
Mr. Atkins, how many different incidents are covered in the CAD calls that we just reviewed?
3 incidents, Your Honor.
Okay. How many different 911 calls do we need for each incident?
So, Your Honor,
Mhm.
there is, let me get my notes.
These are all like, okay, go ahead.
So for the Club Crucial shooting, which is going to be letters JJ, like the exhibits are going to have that when we introduce them. There's only one 911 call.
Okay.
So that one's easy. For Adele Drive,
Mhm.
there is 4 CAD reports, 4 911 calls.
Okay.
The state wanted to introduce multiple of these.
And why is that?
So, Your Honor, a couple of these is, for example, and Adele Drive is a good example of this. APD gets multiple calls from different neighbors.
Right.
And so in the state's mind, there's some relevancy to kind of some initial chaos of when these, because some of police work or investigation of cases. And so in real time, when it's 2 a.m. and someone's house is shot up, sometimes they get 5 calls. And sometimes they're half a block over, 2 miles over, and it takes APD, as it would anyone, some time to figure out where it happened. So I think it's important for the jury and evidence to exist to show that process, real 911 calls and CAD reports associated with acts in the case that come in real time. They come in fast, and APD has to decipher and figure out what happened, which leads to investigations.
So are we going to need to listen to 4 different 911 calls? I mean, it's easy enough to say, are these the 4 CAD reports? Yeah, they are. They're admitted.
Your Honor, specifically with the 911, we will not have to listen to 4 911 calls.
Okay.
And so there is specifically for at least Adele Avenue, the 462 911 audio, that is the 1428 is the victim's address, and that's that's the victim's, I believe, niece calling.
All right.
And so that a 911 call the state wants to play.
Okay.
And there was, of the 3 other calls, the 455 the state wanted to play because these CADs come in sequential order. And so the first 911 call that we have audio for and is in the case file is 0455. So the state wanted to play that because Ms. Latner's kind of explains how they associate cases together when they get multiple calls. And so I will not play the audio associated with 460 or the audio of 456.
Okay, you can just say there were 2 other ones. Here are the CAD reports.
Yes,
okay,
Your Honor.
super.
And for Drew Drive, we have 1 911 call, 2 CAD reports. So 0587 has a 911 audio, and 0588, which is the one right after it, is just a CAD report.
Okay. All right, thank you.
Yes, Your Honor.
Okay, now Ms. Love to the Ms. Love or Ms. Hilton, I don't know if it's going to.
Excuse me.
Okay.
So that says to Mr. Stillwell's calls.
Yes.
We just narrowed down the area that we were going to be intending to introduce. And of the bucket of calls that are in the folder for Mr. Sprinkle under defendant Stillwell, we've identified for the defense the October 31st call, 2015 at 12:26 p.m. from 1 minute and 10 seconds to 2 minutes and 5 seconds. We have eliminated the November 9th, 2015 call at 12:04. We've discussed and do not agree on the November, well, we don't agree on any of them. Mr. Sharp wanted me to make sure that I was clear. We don't agree on, they don't concede any of these, but November 9th, 2015, 1627 and 1645, those are 2 different calls. We are keeping those. We have eliminated the November 9th, 2015 call at 10:57 p.m. The November 10th, 2015 call at 16:41. We are introducing the portion starting at 1 minute and 50 seconds to 2 minutes and 30 seconds. And then the portion at 5 minutes and 51 seconds to about 6 minutes.
Okay.
Then the November 13th, 2015 at 16:58 call. We are introducing the portion from 12 minutes and 40 seconds till the end, which I believe is about 15 minutes. The November 18th, 2015 call at 17:30, we're introducing the portion from 10 minutes and 45 seconds till 11 minutes and 21 seconds. See? You want me to continue?
Yeah.
The November 18th, 2015 call at 18:43. We are introducing 1 minute and 52 seconds till about 4 minutes and 35 seconds. So 1:52, the call starts, and then 3:20 to 4:35 is a specific portion that we have identified to Mr. Sharp, but we may have to back it up a little from 3:20 just for context, but 3:20 to 4:35 is the portion that we
Okay.
identified.
Is that all of them?
No, there's a couple more.
Okay, go ahead.
So November 19th at 17:26 from 2 minutes and 15 seconds to 3 minutes and 50 seconds. November 19th at 19:35. This is 1 minute and 27 seconds to 9 minutes and 20 seconds. November 19th, 2015 at 19:35 is 1 minute and 27 seconds to 9 minutes and 20 seconds.
Okay, give me just a second. Okay, this is just one.
So 19, okay, I'm gonna repeat for Mr. Sharp. November 19th, 2015 at 19:35. We will play from 1 minute and 27 seconds to 9 minutes and 20 seconds. Then for the call dated November 23rd, 2015 at 16:08 p.m., the state will play from 8 minutes and 50 seconds until the end of the call at about 15 or 16 minutes, actually. It's about 7 minutes. 8 minutes, 7 minutes. Then December 4th, 2015 at 15:48, the state will play 11:57 to 13:15. Then on December 4th, 2017, at 17:31, the state will play 8:10 to 8:30 approximately. And finally, on December 7th, 2015, at 16:55, the state will play from 13:50 to 1600.
Okay, so do we want to just start with the first one and I'll hear what the objection is, or hear the tape and then hear what the objection is? Maybe hear the objection and the tape.
So, Your Honor, I think that's a good way to do it. Maybe hear the tape and then the objection.
Okay.
The reality is, I've listened to all these calls, but I'm not going to be in an agreement with the state, so we're going to have to litigate it. So there's not really any sense in further negotiations,
Sure.
respectfully.
I mean, we at least have the portion that they intend to play now.
Yes.
Okay. All right, so if you want to just start with the October 31st one and play that portion that you intend to play, and if I need to hear, well, I assume if you intend to play it, it'll give the jury enough context also. Is there like a general objection on all of these, or is it going to be different depending upon?
Well, I will note that several of these calls involve people threatening Mr. Stillwell and him reaching out for help to stay alive because the system has placed him in a cage with people who are potentially trying to kill him. I find something rather perverse about the system putting him in a cage in a situation where he needs to reach out to help to survive and avoid having a shank plunged into him, and then us using that against him. So that is my general objection to some of these quote unquote gang related statements. I think we all know about the danger risks and the deaths and stabbings that have occurred at 901 Rice Street. So he's really in a no-win situation there. And I don't know, that just does not, on policy grounds, that doesn't seem like something that should be held against him. He didn't ask to be put in that situation. But other than that, Your Honor, there's different topics, there's different objections.
Okay. Give me just a second.
While we have a minute of downtime, I'm getting dispatches from colleagues that are not here.
Okay.
We wanted to make sure that we're all on the same page, and I guess the court acknowledged that the Mr. Kendrick's video that was discussed yesterday, the video of his interview, that everyone was on the same page that Mr. Kokomo, Mr. Steele were going to provide a copy of that video because it was not introduced at the time we were discussing it yesterday.
Okay.
And I think that everyone wants to make sure that you are on the same page that we will be supplementing the record with a copy of that video.
Right, and I think didn't we talk about that yesterday, that would be Defense Exhibit 1 to that motion? Yeah.
Yes, I thought we
Okay.
did, but
Yeah, we did.
okay.
So it's admitted. The court reporter will await receipt of it.
Yes,
All
thank
right,
you.
Thank you.
Hello.
What's up?
Hey. What happened? Oh, okay. What is that?
You just let him know he behind me, everything good. He said, Doug sent him down there so I can interview him to see if I wanted him. I'm like, feel like he handled the case, then I want him. If you feel like you can't, then don't waste my time.
Oh, okay. You want him?
But he talking like he can handle it, like everything. He can handle everything. He say he been working with all type of stars on all type of murder cases and all type of cases.
I'm sorry.
Okay.
Can't hear that at all.
Your Honor, we're bringing over a Bluetooth speaker. I'll give the court what is being said so that at least we can discuss it. Mr. Stillwell says, when asked how he's doing, that Thug sent the lawyer down for me. I went and talked to him. He let me know he's behind me. Everything's good. Thug sent him down there so I can interview him to see if I want him. I feel like he can handle the case. Okay. I'll start over. Thug sent that lawyer down here for me. I went and talked to the lawyer. He let me know he's behind me. Everything's good. Thug sent him down there so I can interview him to see if I want him. I feel like he can handle the case, and if I want him. If I feel like he can't, then don't waste my time. He's talking like he can handle it. He's been working all types of stars and murder cases.
All right, so the extent of it. Okay.
I agree with the state's rendition of what that says.
All right.
My objection is relevance and 403 specifically, confusion of the issues. So to my knowledge, well, first of all, let me just say this. Factually, I think the state would acknowledge this. I did not represent Mr. Stillwell in 2015. I did not meet Mr. Stillwell in 2015. I am not the lawyer that represented that. I beat murder cases all the time and have represented all sorts of stars. So factually, this creates an impression to a jury that, and I know I'm not a party to this case, but I am linked inextricably with my client. This creates an impression to the jury. A reasonable deduction of the jury would be that he is talking about me, that Jeffrey Williams sent me, and let me just be clear, I have no information that Jeffrey Williams sent anyone, but Jeffrey Williams sent me to talk to Mr. Stillwell and that this is just a continuation of Mr. Williams sent a lawyer. I'm here representing Shannon Stillwell in 2024, and all that is completely false. I know who represented Mr. Stillwell in 2015. I don't know if that's the individual that's being discussed, but it wasn't me. Furthermore, I don't know of any information or any evidence that Mr. Williams ever hired a lawyer on behalf of Mr. Stillwell, or had any role in that. I don't believe that to be true, but the state has not provided any information. So this is misleading. It's confusing the issue. It creates the impression that Jeffrey Williams sent me, current counsel, and I'm continuing to work on behalf of Mr. Williams representing Mr. Stillwell. All that is false, and the state, I would hope, would agree that that is that any impression that it was me would be misleading to the jury. So I'm not sure what the relevance is, but certainly there's 403 issues that outweigh any probative value in this piece of information.
And Your Honor, just to add a bit more context to that, certainly we agree with everything that Mr. Shard has said. We're going to have an objection as well, of course. We don't believe that that conversation that you're about to hear is, number one, irrelevant, that it advances any issue specific in this case, but more importantly, and the state knows this, I'm sure they do, there is no indication, and there, in fact, was not any attorney hired by Mr. Williams for Mr. Stillwell, Mr. Jackson. And so any discussion that the court would hear, that the state would intend to introduce about Mr. Stillwell talking to someone else about Mr. Williams sending an attorney down, or whether he's going to hire an attorney, or the fact that he did not hire an attorney for him, I don't see the relevance. And so that's just adding a little bit more context for the court.
All right, thank you. I'll hear from the state.
Yes, Your Honor. As far as the relevance goes, the fact that the alleged leader of the gang that Mr. Stillwell is a member of is securing for him representation for a murder that is alleged on this indictment, that we allege that other members of this gang committed. And the fact that we allege that, in part, one of the ways that the gang protects its members is to pay bail for arrested gang members and enterprise members, and to obtain and procure representation for them. The fact that Mr. Stillwell is relaying out of his own mouth that the alleged leader of YSL has sent someone down there, and the fact that this person has been, according to Mr. Stillwell, working with all types of stars and murder cases. And he is saying in one of his songs that he's talking about paying a lawyer, having beat a murder rap. I don't think anyone is going to get the impression that Mr. Sharp is the person who represented him. And even if they did, it doesn't in any way impact the 403 analysis, which would Mr. Sharp bears the burden of showing that this information somehow or another is so substantially more prejudicial than probative as to permit its exclusion on 403 grounds. And he hasn't done that except to say that they might think that I'm the one, but Mr. Sharp's not the person or the proper inquiry around which to make that analysis.
All right. I mean, it doesn't actually say anything bad about any lawyers.
Well, I'm not.
Whether they think it's you or not, I don't see what that matters. I mean, if you want me to tell the jury that you want them to know that that wasn't about you because you didn't represent him in 2015, we could think about that. But I mean, it's definitely relevant evidence in that it makes the state's assertions more likely than they would be without that evidence. And
would you consider Two things. I would like that instruction.
Okay.
And second, would you consider taking out the lawyer said he represents all stars and is beating all sorts of, I mean, that's just lawyer puffery. And I don't know why that was said, but at the same time, I don't know why that would come in.
And Your Honor,
Go ahead.
so as it relates to Mr. Shart asserting or asking the court to assert or put before the jury evidence about him, I don't know that that would be appropriate, but we can
Well,
address
I
it
would
at
do
a
it
different
anyway.
time. And as for whatever the lawyer said about him representing all types of stars in murder cases,
Mhm.
the fact that Mr. Stillwell made that assertion is the part that we believe is most relevant, because that means that it was important to him, and that's his belief. He's telling this person that he's saying he can handle it. You know, he's been working all types of stars in murder cases. That repetition of that part of whatever the conversation was is the part that we believe is most pertinent.
Okay, and you're saying that then shows up in a music video, or what did you say about that?
With respect to the music video, I pointed the court's attention to the music video that we heard earlier.
Just that he had beaten a murder rap. Okay.
The
Pay
thing-
my lawyer 30 for that to beat a murder. I just beat a murder rap, paid my lawyer 30 for that.
Okay.
Your Honor,
Me and my slimes above the law.
I'm sorry. The problem is that there's nothing to indicate that there's any connection between that particular lyric that we saw in that video and this conversation that Mr. Stillwell is having with his significant other about an attorney coming to see him. And the important part pardon my seat, the important part, I think, to add into the analysis is that, Mr. Williams does not hire an attorney for Mr. Stillwell. And so there's been an association that's been shown already between Mr. Stillwell and Mr. Williams. And the fact of Mr. Stillwell having a conversation with his significant other, his girlfriend, about whether or not a friend of his or an associate of his is going to assist him in getting an attorney doesn't prove anything. I know they can argue whatever they want to argue, but there's got to be something to indicate that that's a reasonable argument that they're discussing this, or Mr. Stillwell is having this discussion in the context of the quote unquote gang leader getting him an attorney as part of this overarching and ongoing conspiracy. And there's no evidence to indicate that. And then so for that reason, I would say that, again, I don't believe it's relevant at all. I think it does confuse the issue.
Okay.
I'd ask that you've
I
got to hear it.
understand the objection. It is admitted. I will give the instruction that it wasn't Mr. Shard if you want to come up with something like that. And otherwise it comes in. What's the next one?
To address my concerns about the idea that the jury would think that the lawyer in question is representing Mr. Stillwell currently, I'm probably going to include Mr. Botts in that too. It was neither
Okay,
Mr. Shard or
sure.
Mr. Botts.
Okay.
I would also ask that in that instruction that it be added that it was not Mr. Steele who represented or who came down,
Okay.
quote unquote, to talk to Mr.
How
Stillwell.
about it wasn't any of the, was it? I don't know who it was.
Judge, I would,
Mr. Steele.
no,
No.
Or myself.
we don't know that. And in fact, Judge, when we have in 2022 with the murder, with respect to Mr. Steele, we don't know.
Okay, who entered an appearance, if anyone, on Mr. Stillwell's behalf in the 2015 case?
A gentleman by the name of Michael Bixson. entered-
Anybody else?
No.
Was he-
At some point there was, and just to give full context, a lawyer was not, the state keeps arguing that Jeffrey Williams hired this lawyer. A lawyer was not hired for a significant amount of time. He was represented by the public defender.
Okay.
I believe Mr. Bixson was the gentleman who entered an appearance and is being discussed here.
Okay.
And Your Honor, That's not what we said. We just read what Mr. Stillwell said, and that Thug had sent a lawyer down there. We didn't say someone had entered an appearance. He just said he talked to him. So we
Okay.
don't know who it was, and that was the point that I
Well,
was
that
making.
doesn't matter because I'm not gonna say it wasn't Mr. Shart that talked to Mr. Stillwell. I'm gonna
Okay.
say it was none of these lawyers who represented Mr. Stillwell in 2015.
That's fine.
So do you want it to be Sharp bot Steele, or nobody here today?
Nobody here today.
All right.
An entry of
Solves that issue.
appearance.
All right, y'all need to draft it. Give me a second. All right. Next.
Judge, I'm going to try and play it through a Bluetooth speaker rather than play
Okay.
it through the. And this will be the November 9th, 2015 call at 16:27. Just 1 second. I didn't give it's the call, the whole call.
Whole thing.
Hello, this is a prepaid collectible.
It's a little loud. Do it without the mic. I'm going to start where the cost. I'm going to start where the call starts at 1 minute and about 27 seconds in. After the securities.
What's up, bro? Hey, man, what's going on, man? It's fine, someone with, something like that,
It is.
Maybe it is better going through the microphone.
I'm going to try one more time because we had a microphone on. If it does do that, I will play it.
Okay. Honestly, if you put transcript, that might be easier. I mean, was better once you moved that away, but. Still do things. Judge, does the court, is the court able to hear that? Because I'll just play it through Zoom if not. Not really, I mean, I can hear it. Can I discern what they're saying? No. I mean, some of it, but. I'm being encouraged to play it through Zoom. Okay. Do you have a transcript of it? Not one that's really that accurate. Okay.
I don't know what paperwork got going on. These niggas tonight, you on hold and all that. Man, y'all just stop playing with me, bro. Cause I know how to fight, bro. Y'all fuck at me, y'all cap ass shit, bro. I ain't with all this suck shit, bro. All this fake ass gang shit. I was just on the street, y'all niggas just tonight, bro. Everything good, man. Come on, man. You need some hold.
Hello.
And Judge, I'll point to the right of the screen where the court sees the lines indicating talk. That's the transcript that's coming up. It's sort of closed captioning. It's not the best, but that's what I was talking about.
Hello.
Um,
Junior, he on the phone, Junior. Hey, boo.
what's up, little man? What up?
Man, what's up, man? You fuck ass nigga tell all this suck ass shit, bro. You shine nigga, bro. For real, huh? I don't know what paperboy had going on out there, out there like he kicking like he's there with a lower or the fifth or whatever he's doing. Man,
Who said that?
Paperboy, these niggas trying, they don't know nothing about paperboy, man.
Who are they?
They trying, they shine.
What's their name? Who they big bro?
He's my hit big bro, Montana.
Bro, Montana ain't got no wisdom.
Hey, bro. Come here. My bro said Montana ain't got no rim. Montana, your big bro. Hello?
Let me holler at him.
Hold on.
Stay pause it just a moment. I think this is important to note. At this point, a jail phone is being passed to a third individual. So we're about to hear a conversation between two individuals. Neither one of them are my client.
Okay.
Hold on, boy. He trying to have that something in there, though. Hold on. He ain't got no run, no flow or nothing. What you say, my son ain't got no flow?
Bro, a green light and a
green
floor
light?
is different, man.
Hey, I said here.
Bro. Hey yo.
Bull.
He scared to get on the phone?
I don't know, man. He talking through the door to another nigga, man. These niggas monkey, bro.
Tell a nigga get on the phone.
Man, these niggas monkey, bro. I beat one of these fuck niggas up, bro. I ain't playing, bro. All that lame shit. Come holler at my bro, man. Hold on.
Hey yo, homie.
Yo.
Rise and shine.
I shine, you shine, we shine. Hey, who your big fool, bro?
Yo, my big fool A1, dog.
A1?
Yeah, that's the big bro over Georgia, my nigga, behind the G-Wall, 5. Listen, son.
You talking about behind G-Wall? A1 is behind.
Yeah, A1 behind the G-Wall. Listen, 5. Listen. But we just had a 5 on 031 day, dog. My channel don't even have no rims, 5.
Hey, look.
50. Hold on, bro. My handle is Busy, 5. You can ask any nigga about me, bro. My name's Busy, 5.
Your
My
name who?
channel don't got no what? Busy.
My son got the green light. Joe Shine gave him the green light over the whole right street, dog. I'm telling you, I'm telling you out the Joe Shine house.
Bro,
hey, look, you can three-way Joe Shine right quick.
Hold on.
Hey, bro, call Joe Shine, bro, cause I ain't gonna keep going back and forth on nigga about nothing, bro.
He about to do it, Joe. He about to do it, man.
Straight up, bro. I ain't all this suck shit, bro. All that lame ass.
Bro, and who the fuck is saying that paper? Who put what the paper mouth?
I don't know. I think it ain't Pete. That some nigga named Pete in that though. You thought that ain't Pete, man. Some murder ass shit.
Hold up, bro. I ain't about to do it on 3-way because I don't know how to work my mother's phone.
I got Joe Shine. Hey, new baby.
Huh?
What that phone at?
Is it on?
Man, come on with it. What's your sign number on, boy?
770-255.
Yeah. Yo.
9113.
Okay.
And they said you on hold.
Yeah, I don't know what the hell that shit be about.
Well, what the fuck?
He said my time is the green light, but he ain't say my time ain't got no stain. He said he the green light.
Bro, I know my channel. Find my channel used to be a brown.
He keep telling the nigga that shit.
Bro, nigga know my channel. Dog, nigga ain't saying my channel nothing bad about the nigga used to be brown, bro.
My channel used to be brown.
But that's the only my channel who shine fire and got the green light, dog. I'm telling you something I know, Shannon. Hey, boy, he ain't picking up. He ain't picking up. Where the other man? Where the straight now? Hold on. Hey, yo, call his number.
Hey, who over Georgia, boy?
Hold on. 44 632 6586. Bro, Pop got the whip for Georgia right now. Bro, these niggas asking questions and they don't even fucking know who the fuck is these niggas that say niggas on hold and they don't even know shit.
They don't know what's going on, man. You can find hell nah, man. Fuck these niggas, bro. I don't know that.
Who they saying got it? Joe Shine?
Who got Georgia? Who y'all saying got Georgia? Who he said got Georgia?
Hey, Robin Shine, fine.
I saw what's up.
Bro, listen, you know Shannon and Rice Street, you just went upstairs, right?
Yeah, right.
Listen, bro, these niggas talking about 5 is on hold and all that kind of shit.
Who this is right here, boy?
This buckshot.
This buckshot. Hold on.
Hey, yo.
They talking about what?
They saying that there's 5 is on hold and all this my channel shit. Bro, tell these niggas my channel don't even got no fucking room.
My channel don't got no fucking rims, nigga. That nigga's a slap, nigga.
That's what the fuck I just told these little niggas. These little niggas don't even know shit.
The fuck, what he say? He got the same. Hey, he said his
Bro,
name. He said his name Finesse and another bro named Pete.
bro, and then on top of that, these niggas want to tell me that Pop not running the whip.
Stop pushing the whip, nigga.
That's what I'm telling them.
He said Pop.
Georgia. Pop, man.
Pop. Yeah, he know Pop push.
Bro,
Pop just running the whip, G. That's what got the rims by now, G. This shit going on. Hold on, like that, bro. Yo.
Hey, yo,
Yo.
Who is saying that Shannon is on hold?
Huh?
Who's saying Shannon on hold?
My the green light over here, Lil Pete.
Look,
Look, let me tell you what the situation going on right now. Joe Shine gave him the green light over on 6th floor. Goddamn, Montana got the green light over the whole right street, right? Goddamn, the hood we pushing is living proof or no proof, right? Y'all say the high is hot. No, Pop. The high is not Pop, bro. The high is Doug, bro. Doug Ski, bro.
Bro, Doug is not. He's inactive right now.
It's a bunch of politics going on with Doug right now, Chief.
But them niggas
Hold on. See, look, we've been in Right Street for a good minute. See, we ain't been pulling up at no jewelry shop. You feel me?
Yeah. But fine, look, yo, you right on paper. Dub is the high, but bro, this nigga is inactive right now, fine.
You got a three-way with Joe Shine?
Bro, call this nigga Joe Foster. They just so fixed on this nigga Joe.
I'm bar Joe right now. Tell Lil Pete they follow Joe right now. Tell Lil Pete they follow Joe right now. Hello?
Yo.
But what you saying though? Let me put me on drink. What's going on?
Hold on. Who you be?
Unless I be that started slim finesse on banging that original ice. I said G Shine one have one whole double OGs. All I know banging for G Shine. What we do, living proof or no proof.
Hey yo, what pop fool? Hey fine, hey Joe Shine, listen fine. Alright, did you get a nigga Montana the fucking green light over Right Street?
Montana, yeah.
Alright. Okay, who the fuck is Pete?
Pete?
Yeah.
Petey?
But look, really, I was telling you, look, we don't give a fuck who these niggas is. Bro, these niggas talking about Shannon's on hold and all that shit. These little niggas on the phone now, dog. Get these niggas right.
No, they tripping. Leak me in. Hey, Joe Shine. Yo, Joe Shine.
Listen. Yo, Shannon is not on pause. It's not on pause, bro. Shannon is
down low.
Fit to hurt, bro. Shine.
Hey, look, down low.
10%, bro. He's hurt.
Down low. Hey, look, we just
listen, bro. Y'all matter of fact, bro. Listen, bro. Just listen, bro. I'm gonna tell you everything you need to know. Y'all niggas listen, bro. Shannon is not a dub. He's not on pause, bro. He's Shine, bro. He's official hurt, bro. He's in the lineup, bro. He's in tune, bro. So y'all are to embrace him, bro, and stand behind him as so, bro.
All right, down low. I'm gonna put Pete Drake on that right now.
Tell Montana. Tell Montana I said this. Don't like tell
Montana. No, Montana downstairs. They bummed me up to the 6th floor.
Okay, listen, you need to let all the bros know. You talk to me today. The big bro, you let them know that I said Shannon is Shine, bro. And everybody face him and stand behind him and so.
Down low.
Hey yo.
And tell them they need to be getting at me beat up, bro. I need to hop. They got Trey One to bust at me, bro. Everybody got Trey One to bust at me, bro. I need to hop in all the bros in Right Street.
Down low.
Hey yo, Doug, you know Shannon's situation. The only reason why niggas called this time because these niggas really don't know shit for real. But you
look. This way it happened. When he bombed in, I was like, you shine? He was like, yeah. I was like, ride and shine, twin. He was like, I shine, you shine, we shine. So I was like, all right, what hood you pushing? He said, living proof or no proof. All right, down low. So I bust that Lil Pete. Lil Pete said, do he know his oath? He didn't know his oath. You know how that is. If you don't know the oath in 3 days, you ain't shine. You feel me?
Hey yo, but fine. Hey yo, if I just asked you who you be, fine, and you didn't even have a mandatory shit in your who you be, dog. I did just tell you who I be. Bro, the only thing you had in there was double
Hit him up.
OSG.
Hit him up right now. Hit him up. Hit him up right now.
Unless I be that first slip from this, so bang that original ice I said G-Shine, one half, one hole. Number 01 G's up is all I know. Thanks for two shine what I do, living proof or no proof. Blah.
Bro,
Hey,
listen, this shit just said 1 minute, bro. You gotta try to ball back, bro. Y'all niggas need to ball back, shine stuff. Everybody got Trey one to tune in with me, bro. Everybody in Rice Street got Trey one to tune in with me, bro.
But you don't know all these little niggas thinking they got stains,
I don't know them, bro. I know Montana, bro. And that's the only person that I stand behind, bro. Whatever Montana got going on, that's what he did. Oh yeah, they good brand. All them come from Montana, bro. They good brand. I agree like the Montana do that, bro. They great brand. With everything else, bro, they just need to tune in with me, bro. Y'all, bro. Everybody in Rice Street got to tune in with me.
Hey, yo, part of my soul, who the heck is that's on the line that's in Rice Street right now?
Here's your name, though. Oh, Chase, fine. Damn, we gotta get him the ball back. Hey, look, why the fuck y'all at Buckshot and Young? I need to have a y'all niggas bad about some more shit. Shut up.
I'm in the
All right, look.
Thank you for using Securus. Goodbye.
Okay. So, just before I get started with the facts, I do not accept Miss Love's assertion that I bear the burden of proving that prejudice substantially outweighs probative value. I believe that they bear the burden that it doesn't. They're the proponent of the evidence. That being said, what we have here, just in context, Your Honor, in November of 2015, Shannon was in a car on University Avenue. People shot into the car, tragically shot a young lady in the face, causing the car to crash and flip over several times. Shannon and the mother of his child were sent to the hospital. Shannon had a collapsed lung, several broken bones. While at the hospital, Detective Thorpe took out a warrant for Shannon for the murder of Donovan Thomas. Once Shannon was finally medically cleared, he was brought directly to Rice Street and dropped into this environment where he is wounded, hurt, and apparently, from the context of this phone call, individuals who seem to be associated with the Bloods started threatening him. I believe the context of this call suggests, if I'm being candid, it suggests that Mr. Stillwell calls an individual and asks him to tell the people that are in jail with him to basically get off his back and stop threatening him. It's clear from the context, and that's why I said what I said before we started with this is the idea that Shannon has to do this to survive and stay in Rice Street, and now it's being used against him. I don't particularly care for. From the context of the call, it appears that Shannon is associated with G-Shine, which are Bloods. It appears that this individual he called for help communicating that he should not be attacked is associated as well. And then an individual by the name of Busy, who is locked up and apparently has been coming at Shannon, takes the phone and talks to the individual that Shannon called. They have an argument over blood politics. Shannon, there's no indication, has any part in that argument. I don't know where Shannon is at that time, but they have an argument over blood politics, over who runs this, who runs that. One individual thinks a gentleman by the name of Montana is calling the shots. The other individual is saying Montana doesn't have the authority to call the shots. But either way, the message is sent. Shannon is hurt. Shannon is injured. Don't mess with Shannon. If this were a case about the G-Shine Bloods, my argument would be more difficult to make. This is a case allegedly about YSL and the alleged gang, criminal street gang YSL. Now, the state believes that they have this unbeatable argument, which they've brought out dozens of times already, and I'm sure they will again. Well, this is a hybrid gang, so therefore everything's relevant. No, it needs to be specific. They're saying that YSL is an entity, is a criminal street gang, and they're moving together to for a common purpose. This has nothing to do with YSL. This is internal blood politics, internal G-Shine politics, and quite frankly, my client just trying to survive in 901 Rice Street. Additionally, Your Honor, there's another concern that I have, and I would assume Mr. Adams has too. There's an individual, they're talking about who runs things. There's, and one individual thinks Montana runs things. And then there's talk, again, when Mr. Stillwell is not on the phone at all, that a gentleman, and what I believe is said, is Dub. A jury hearing that could quite possibly misinterpret that as Thug. I was concerned, I heard that at first, but that is not the case. So that's another wrinkle into this, but I don't believe any of this is relevant. I believe it's highly prejudicial. It's not relevant to this case, I should say. It's highly prejudicial. It confuses the issues. And for a substantial amount of time, I did not note the starting time, but from a time till 8 minutes, Shannon is not even a party to the conversation. A certain time, I'll say around 6 minutes, but I didn't note the exact time, to 8 minutes, Shannon is not part of the conversation. And from 10 minutes and 40 seconds onwards, Shannon is not a party to the conversation. So it's unclear to me how this could be labeled statements by a party opponent and be admitted that way, or any sort of admission. Finally, Your Honor, I don't think I need to say this, but we have not been noticed that any of these individuals in this phone call are on the state's witness list, so we will not have the opportunity to cross-examine any of them.
All right. That conversation was clearly not testimonial.
I understand.
Your Honor, with the court's permission, I'll address the issue of burden in a moment, but I'd like to just start out by talking about the relevance. Mr. Shart's assertion regarding the fact that this case is against YSL is, and therefore any calls that defendant Stillwell makes to have someone verify his blood gang credentials are therefore not relevant, is belied by the part of the indictment wherein the state asserts YSL claims affiliation with the National Blood Gang, and that some associates also claim the blood subset gangs, Sex, Money, Murder, and 30 Deep. We also go on within the indictment to discuss that YSL, as Mr. Sharp correctly stated, is a hybrid gang, that they actually have members of both Bloods and Crips. But specifically, we also assert that YSL associates often use and write the word black, which some of our witnesses have come forth and said means other things than what our experts have said, which is blood love all the time. The court heard within the context of this call a reference to G-Shine and Shine. As Mr. Sharp correctly asserts, G-Shine is also a blood gang subset. And Mr. Someone to have the authorities come and have these people get off his case. He called another blood gang member. He had one blood gang member get on the phone with another in order to verify and validate his credentials as a bona fide blood gang member. So we would argue that Mr. Stillwell's words are words of a party opponent, that the words of the person who spoke on his behalf when he gave him the phone is an adoptive admission. He's making these assertions on behalf of Mr. Stillwell. And regarding, so in terms of relevance, our argument is that it very easily passes the low hurdle of relevance. And under 402, it's therefore presumptively admissible. And under 403, Mr. Sharp has not made any showing that it is substantially more prejudicial to Mr. Stillwell, such that the evidence would create a risk that defendant Stillwell would be convicted on a ground different from proof specific to the offenses charged in the indictment. Regarding the objection burden, Your Honor, I'm citing a line from Carlson on Evidence 8th edition that, echoing federal authority, Georgia cases have placed the burden of demonstrating a violation of Rule 403 on the objecting party. But the case that I'll cite is State versus McPherson, 341 Georgia App, 871. And the pen site is at A74. Specifically, in discussing or analyzing whether or not there is a 403 reason to exclude the evidence, the court says that it finds no basis in the record to support the extraordinary remedy of excluding this evidence as unduly prejudicial, particularly given the strong statutory presumption of admissibility. There has been no showing that the evidence would confuse the issues, mislead the jury, waste time, or be cumulative of other evidence, or that the probative value of the evidence otherwise would be substantially outweighed by its prejudicial impact. And the fact that they're saying that there's been no showing.
But it's that because at that point it's on appeal.
When the court says,
are you talking about at the trial court level, somebody didn't show, or here on appeal? Because that's
I
different.
see what the court said. Okay.
Yeah. I think it's.
If the court would give me a moment to analyze that aspect of that case. So the court references later on, in this case, there has been no showing that the potential witness's memory about the alleged incidents is either impaired or patently unreliable. Just one. So, Your Honor, my reading of the case is that in this particular case, in the record that they're looking at, the record below, that there was no showing in that record, that the evidence would confuse the issues, mislead the jury, waste time, or be cumulative of other evidence, or that it would be substantially outweighed by its prejudicial impact.
All right,
Maybe
well,
we answered the court's question.
be that as it may, 403 is a balancing test for the court to apply. So
Ms. Love, are you done?
So I might have a little bit more, but if I may cede the floor to Mr. Sharp for a moment and come back.
okay.
All right.
Okay. Two things. The state thinks it's relevant that Mr. Stillwell called someone else for help because he didn't call the authorities. He's in jail surrounded by the authorities, put there by the authorities. I don't know who he's supposed to call. He's around law enforcement. He's not being protected. As far as adoptive admissions, there are 2 phones. There's not an ability to have a party line in the jail where you can just pick up a 3rd phone.
There's not supposed to be an ability to have any kind of cell phone, but
I agree.
anyway.
But in this scenario, another individual has the jail phone. The idea that Mr. Stillwell has adopted what's being said because he doesn't pummel the man with the phone, retake the phone and say, no, that's not true. When A, he's not hearing what's being said because he doesn't have said phone. B, we don't even know if he's next to that person. And C, there's not a phone for him to speak into to deny what's being said is preposterous. So it's not an adoptive admission.
So when does Mr. Stillwell, obviously Mr. Stillwell starts the conversation. He gets back on the phone 2 different times.
No, he actually is on the phone where Mr. Sharp stood up and said that from here on out, this is not going to be him. You hear him throughout that portion. You hear Mr. Stillwell throughout that portion talking on the phone at various times. There is a point at which the talker on the person to whom he gives the phone says he went upstairs, but then you hear the person to whom he gave the phone to speak on his behalf continue to assert his credentials, and his being the person now talking, his own credentials to speak on behalf of Mr. Stillwell and to assert his validity as a blood gang member throughout the call. So it's at various points, and I could go back and, obviously I could sort of demarcate those specific times where you hear Mr. Stillwell's voice, but there is not a point at which you stop hearing his voice 3 minutes in, and now it's only these 2 people calling or talking. And it's certainly not a point at which you expect Mr. Stillwell to pummel this man because he's making these assertions, when Mr. Stillwell placed the phone in the man's hand precisely to make those.
And it's almost like he's an agent for Mr.
Yes.
Stillwell at the time, somebody speaking on his behalf. I mean, I am going to overrule the relevance and the 403 objection. I find these to be either admissions by a party opponent or adoptive admissions. And it also probably, to the extent neither of those covers it, I think both of those cover it. So.
Your Honor, will you grant me, for all of these rulings that do not go my way, will you grant me a continuing objection?
Yes.
Thank you.
I'm going to presume that we're under the Harvey rule. So I'm going to adopt everything.
Haven't taken that back. So that's what we're operating under.
All right.
All right. Let's move to the next one.
Yes, Your Honor. The next one is going to be November 9th, 2015 at 16:45.
Hello, this is a prepaid collect call from an inmate at Fulton County Jail. This call is subject to recording and monitoring. You may start the conversation now.
Hello.
Hello.
Hung up on her.
Yeah.
Try to call
Yeah.
her.
Nah, I said it did like 1 minute.
Try to call for 5 minutes.
That's what I'm saying. It did. I hope this shit don't fuck up.
Everything good. What are you talking about?
Yeah, he told me everything that you still. You know, you still sign or whatever, you official or whatever. He said he gonna go up there, tell Pete, and he gonna tell everybody else in the jail. But he said he did get that boy green light over on Rice Street. He said, but tell him, yeah, they gotta be behind you 100% because you hurt. I'm trying to see if that, what's it? All I said is see if that bull call 698. I remember when people text me from that number when his phone broke.
They just told you what was going on. They said nigga supposed to be behind you 100% of my situation. Hello?
Yeah.
Oh. Hello?
You want me to call them back?
Yeah.
Which one, bull? Well, I'm calling so fast, I don't really know what bull is. Hello. Because I think I don't sit on the phone because they were still talking. I just hung up because you weren't on the phone.
All right, call for 5 minutes.
Joe. Yeah, but Joe.
Yeah. Hello?
Yo.
Yeah.
Yeah, but what's happening?
What's up, bro?
Why you niggas screaming this nigga my channel name like my channel just that type of nigga, bro?
Exactly, bro.
Come on, niggas know this man. That's why, bro, that's why I joke, man. Niggas like, oh, this nigga just be giving niggas the green lights and shit. And it's like, come on, son, you not even about that kind of shit.
These niggas tripping.
Pete, the fuck, man, you really need to be a rolling.
Niggas don't know what they be getting themselves into. These niggas don't know what's going on, man.
And he's so quick to be like, you don't know your oath. You don't even know the real who you be. I said, I told you to get on this shit, dog. I told you I had you, five. I told you I had you. Like, niggas ain't saying niggas jinx you to go back to jail, but bro, the life niggas is living, it's a chance, five. And I told you niggas was cleaning shit up, dog. That shit gonna be way, bro, God forgive, dog. Forbid, bro, that shit gonna be way worse behind the G-Watch, I'm telling you.
Hey, Dread on the phone.
Yo, what's good? Hey, you hear me?
Yeah.
I don't know how niggas gonna get it to you because they fucking that crazy shit, the mail situation. But bro, you got to know that shit, bro. That's the first thing niggas gonna ask you. That's the first thing, especially if niggas don't know you. You just so happen to fall into a dorm, niggas really don't. You know what I mean?
Yeah.
But you got to know that shit, bro. But still though, them niggas don't even know shit. They just, they been in the dorm, so they got a little establishment going on. And they ain't even around no real right niggas.
Cause I keep screaming, Joe Shine, Joe Shine, Joe Shine.
Man, this nigga Joe Shine is all the way on the fucking east side, man. Niggas, I was just with this nigga. The only people this nigga Joe got like right up under him is like his brother Bart and some other nigga. All these other niggas, dog, these niggas don't even be real right. Me and Joe got into it at least 2-3 times since I've been up.
Yeah.
So what the real nigga doing now?
Talking to the other nigga too, though.
What's their handles? What's their handles?
My nickname is Vanessa.
Vanessa. Where they from?
I don't know where these much ass niggas from, man. These niggas,
man, you good though, dog. They so big on fucking hearing Joe. Nigga Joe say you good, so I mean, they too big on hearing Joe. That's how I know them niggas on those shit.
Right.
And then I
wish you was over here with me on this side. Man, fuck y'all nigga, bro. Straight up. And I'm with that same shit when I was well. I don't give a fuck about these niggas, bro. Straight up. These niggas know how to hit you on the phone. He just shake my hand, just shake. Bitch ass nigga, you gotta stop playing, man.
And then on top of that, who the fuck is y'all niggas to say niggas on pause and you gonna come out your mouth and say you ain't been in no jury shot?
These niggas, man.
Finesse me, whatever. Hey, so where my chin at?
I don't know. I think he said my tongue downstairs.
This nigga got the whole right street, not even on the 6th or 7th floor. So crazy, man. Hey, yo.
Hey.
What's
man,
up?
look, man, I love y'all, bro. What's that new baby?
Yeah, I love you too, dog.
Alright.
Love you, Joey.
Love you too, bro.
Love you, bro.
Alright, love you, bro. I'm calling out tomorrow.
Alright.
Hello?
Yeah.
Yeah.
Y'all crazy.
You nigga monkey, bro.
I'm just thinking like how it works. I don't know. Oh my god.
We gotta get this shit straight before the situation gets situationized.
So stupid.
My apologies. I didn't note the time that we stopped it, but it was before the end of the call. So it's about midway, just a little after midway. Okay.
I think that's all they.
I'm sorry. Yes, that's it.
Obviously, Your Honor, I won't repeat myself, but I'll incorporate my argument from the previous call regarding this being evidence that Shannon is G-Shine, not YSL. YSL has nothing to do with this call. And perhaps the state wants me to state specifically what the prejudice is, I guess, but I think it's pretty self-explanatory. It's prejudicial for the jury to be informed that my client has alleged gang affiliations that go beyond what is charged in this indictment. And so it is prejudicial to the evidence of my client's gang membership, to the extent, obviously, my stance is if it's evidence of membership in YSL and shows that YSL is in fact a criminal street gang, I understand that would be evidence in this case, but evidence of gang membership outside of YSL is prejudicial. That's my argument. And really, Your Honor, this call is just a recap of what had transpired 18 minutes beforehand in the previous call.
So I'm interested in you addressing, is there anything additional in this call that's not covered in the other one?
So no, what this call did was belie the assertion that Mr. Stillwell wasn't making those assertions that were made by the person he gave the phone to. This is Mr. Stillwell, but this is it basically coming from his mouth that that's what he was doing.
Okay, well, I think it supports them, that argument, but it doesn't need to come in separately to the trial.
Yes,
Okay.
Your Honor.
All right, next.
Your Honor, so are we saying that that's coming in or not coming in?
It's not cumulative.
The next one is a short one. It's November 10th, 2015 at 16:41.
Maybe we'll do this and then if lunches are ready, we'll break for lunch.
Yes, Your Honor. I did, November 10th at 16:41. Twice. Okay, it's the same one. And I'm going to start, Your Honor, at around 1 minute and 30 seconds to about 2 minutes and 30 seconds, which is 1 minute. And then I'm going to go from 5 minutes and 51 seconds to 6 minutes, which is about 9 seconds.
Man, Zoo in the same dorm.
Yeah, what you told those do?
Who?
What I told those do?
Damn, man.
We can look, yeah.
I'm talking to my man after the phone, man. So I gotta put someone on that book right quick.
How much?
I don't need nothing but a 20, so I'm trying to make the little store right quick. I know she
I got it.
You got it, but you can't put it on. You at work, nigga.
Yeah. Who need to do it? Tell somebody to do it. I can't live my man.
I don't know. Do this shit. That's what I'm trying to see. I think you can call. I think you can do it online. Call 1113 real quick. You still got a number?
Nah, I got a new phone. I ain't got nobody's number.
I'm giving you number.
What it is?
678.
Hold on.
I'm going to fast forward, Your Honor, to 5 minutes and 51 seconds.
Slug and DK on third floor.
Yeah. We trying to come in.
Yeah, man. I'm good, really, though. I'm like, I'm chilling, man.
And Your Honor, that call has to be, the pertinence of that call has to be, is realized when it's played in conjunction with another call that I'll play with the court's permission whenever it's time to play the next call.
Okay.
Your
Where
Honor,
they.
maybe I can help us out.
Okay.
That's not my client. And nor is the other call. The state is attributing calls that are not my client to my client.
Okay, well, that might be an issue you'll need to sort out at lunch. Let's go ahead and take our lunch break. Let's do 1:15.
MS-13 gang member here illegally, robbed a pregnant woman, then released, then executed a
envy me anyway, man.
Yeah.
Pussy asshole. Good asshole.
What the hell? You don't know. Wait till you get your package.
That fuck nigga envy me anyway, man.
Yeah, I got one crazy relationship.
Fuck nigga envy me. He hates everything I had.
Y'all be back rocking this all over.
Crazy fuck. I don't know that bitch. I really gotta shoot myself in the face. Gotta go back right. I don't want to fuck that nigga, man. They just want this little young nigga ass in here.
That ain't funny. I know you laughing.
I wasn't laughing. I was just like, eat that baby.
Shannon, shut up.
Your Honor, could we pause this for a second? Your Honor, I understand that this is going to be a statement about my client speaking about Woody, who is Kenneth Copeland. I would just ask for context if we could just start. I believe that they started in the middle of the conversation about Woody. Okay. And so I think if the state's going to insist on playing this, we should start when my client's conversation about Woody begins.
Okay, do you know about when that is?
I have in my notes, and these are imprecise, at 10:40.
Okay.
Today, that I did to you in 10 days.
I might get about that fried.
Huh?
I might get about that fried. And we can talk. We can talk. Drew came back with him yet?
I guess so. But she was a lot of pictures and said I asked for a selfie. He sent his waist and below to her. She like, I asked for a selfie, but I guess this would do. With a heart.
That's what the whole world about. Yeah. All right. I go put my boot, I go to jail back. Yeah. You know what it is?
You know what? I told you, I had wrote Treasure like, oh, we didn't know he had the same charge because Lloyd said he didn't.
Yeah.
They said I'm gonna text back. Lil Woody on the phone. He said, what did he say? I don't know. He said you told Trez they dropped the charges on him. He wanna know what was said. I said I never said they dropped the charges on him. I said I didn't know they had the same charges. Oh, I guess that what Trez was talking about. Okay, thank you. But she
They trying to sit up, push that out for a nigga slap.
I don't think she gets much. I would tell her.
Stupid ass bitch. You and your push ass baby daddy got in there, fuck ass. Y'all both y'all on that lane, suck ass, little boy ass shit. Push asshole. Good asshole.
What the hell? You don't know. Wait till you get your package.
That fuck nigga envy me anyway, man.
Yeah, I got one crazy relationship.
Fuck nigga envy me. You hate everything I had.
Y'all be back rocking this all over.
Crazy fuck. I don't know that bitch. I really gotta shoot myself in the face. Gotta go back right. I don't want to fuck that nigga, man. They just this little young nigga ass in him.
That ain't funny. I know you were laughing.
I was laughing. I was just like, eat that baby.
Shannon, shut up. Let me find for you.
I hear blood and he ain't real right.
He what?
He ain't real right, fucking blood.
He what?
He ain't real right.
What? Shit, you know your own?
It be different shit. Like, nigga push up on different niggas. And the wrong way. Nigga pushed up on me the right way. Nigga pushed up on him the wrong way. Like, hey, bro, you got to go and do this. Man, we finna goddamn go and get at you, man. You know, they did. They pushed up on me like, shit, bro, you know, they saying, man, listen, man, do you want to talk to these people because you stressing these big hoes, but you ain't on the phone with these folks. I got these folks, man, you want to talk to these folks. Yeah, bro. Now these niggas be goddamn. I be asking, I like, bro, you got up for rug, bro, but you in here panhandling, bro. Y'all niggas just big.
Shut up.
But hey, man, that's y'all big. Y'all choice. Y'all business.
I feel like I'm wild the clock. What I am.
You got shit.
I can take that.
What you said?
I said I feel like I'm round the clock. I said, well, I am.
You have 1 minute left.
Stopping at 15 minutes and 5 seconds.
Okay. Your Honor, from 11:25 to 13:30, there is discussion about Woody, Kenneth Copeland, lying on my client, and having my client falsely accused of these charges. That is one aspect of what was just played. After 13:30, there is a brief discussion, as far as I'm understanding it, about the previous calls, about the same subject as the previous calls, where we're talking about the Bloods, quote unquote, pushing up on Shannon. Very brief discussion. And then we get into stuff that, quite honestly, I'm not tracking or following, but I don't believe it has any relevance to this case. To the extent that 11:25 to 13:30, I would object. For the record, I don't think it paints my client in the best light, but if I'm forced to deal with that, I'll deal with it. That's 11:25 to 13:30, but I think that's the extent of what is admissible, or what is relevant at all in this case.
Thanks eBay Motors for helping me find the parts that perfectly fit my build.
So, given that Mr. Sharp concedes that Mr. Stillwell's commentary about Kenneth Copeland and Kenneth Copeland telling on him and his expressed feelings about Kenneth Copeland are relevant, our position is that that portion, I agree, is relevant because it is talking about his feelings and his knowledge of a witness in this case. And the fact that the witness is telling on him about things that have to do with this case, we would argue as well that that is relevant and therefore admissible. And there's nothing that is substantially more prejudicial about that information than probative. The portion after that where after Mr. Stillwell is asserting that people envy him. And he starts talking about the guy that just got beaten up in the jail. Defendant Stillwell asserts that he's a blood, he ain't real right. He's acknowledging his awareness and his use of the terminology, he's not real right. He's not a real blood. He's supposed to be a blood. And I believe that the female asks him, does he know his oath? If that's not what he's saying, that's what I heard, and that would make that relevant to us. Mr. Stillwell then starts talking about, I believe, the way that law enforcement spoke to him, or how he was approached about talking, and how law enforcement, how other people were approached about talking about the facts of their case. And that colloquy is relevant. He's particularly as well for what he's not saying, as well as for the fact that he's aware that he is being asked to talk about things and how he's dealing with that. So our position is that it's not substantially more probative. There's nothing in that span of the call that is substantially more prejudicial than probative.
Okay. Honestly, that was the way I took that last part about getting pushed up on the right way or the wrong way. My impression was he was talking about law enforcement as well, wanting to have him say whatever he was going to say about the case. So I think that would be relevant. And I mean, if you can shed more light on it, go ahead. But that appears to be the topic of it.
I mean, the only thing I can do is ask everyone to listen to it again. I mean, we might just have a difference of opinion, but when I've listened to these calls, I'm of the belief that, I mean, all this has been discussed in the previous calls, but he's talking about people pushing up on him, which
In the jail.
in the jail.
Is that what you think it
Yes,
means?
I mean, that's what I believe it to be. And so I
Well,
understand that Your Honor has already ruled one call in. I think at this point it's becoming cumulative. I didn't hear the thing about the oath, but to the extent that the young lady is talking about Shannon needs to know his oath, which I didn't hear, but to the extent that that was said, I mean, that was said in the previous call. So to me, the talk about Woody, I believe it's fair and accurate to say that it appears that Shannon's talking about Woody when he says he envies me, he always envied me, but that ends at 1330. So that's my stance, is any relevance, which I know that the state's arguing it's relevant and it passes the 403 test, ends at 1330.
All right, well, can you start from 1330 again?
Yes.
I know you were laughing.
I was like, eat that baby.
Shannon, shit. Oh. Let me find one.
Your blood and he ain't real right.
He what?
He ain't real right, fucking blood.
He what?
He ain't real right.
What? Shit, you know your own?
If he different shit like nigga, push up on different nigga. And the wrong way. Nigga pushed up on me the right way. Nigga pushed up on him the wrong way. Like, hey, bro, you got to go and do this. Man, we finna goddamn gonna get at you, man. You know what they did? They pushed up on me like, shit, bro. You know, they saying, man, listen, man, do you want to talk to these people because you stressing these big hoes, but you ain't on the phone with these folks? I got these folks, man, you want to talk to these folks? Yeah, bro. Now these niggas be goddamn. I be asking me, I like, bro, you got no Ferrari, bro, but you ain't help panhandling, bro. That nigga had to big. But hey, man,
All right.
that's how it is.
Whether it's about how people are treating him and other people in the jail, or law enforcement. Certainly the part about certain people being bloods, but not being real right. I think that's all relevant and not excludable under 403. So I'm gonna allow this over objection.
Thank you, Honor. The next call is November 18th, 2015 at 17:30, timestamp 10:45 to 11:21.
Nigga, what my good call that? You been a hole, man.
Hell nah.
What the hell wrong?
Shit, man. I mean, all these fucking slimes in the door, man. Hell, these young come here back to back. I'm talking about all along.
Listen,
Fat
they-
ass in here.
Yeah. So you was fatter than you wanted a twin in.
Yeah, twin in here. Fat in here.
I got the same on.
Yeah.
Oh man, you ain't seen none of them suckers.
Man. Oh, nah, I ain't seen nothing.
Yeah, it's right, man. Greg don't come upstairs. I say, I know this nigga. I told him the same thing. You know, you might be going there now. I know you gonna go there.
I had them for, I said, shit, how long I'm supposed to stay out here? They like, shit, we finna pay you upstairs today. I like, shit, yeah, what's it?
Yeah. Well, so what you don't heard? You ain't heard that? I ain't talking to nobody like no now on them damn detectives I can't talk to you now.
I don't want no, I think for the court tomorrow.
Yeah, I heard it was on Thursday. I think, yeah, somebody said Thursday.
Yeah. Yeah, ain't on that.
So that would be your first time saying move to all of them.
Nah, I seen most on last week on the 12th.
Yeah, what?
On the 12th. We went to court on the 12th. We've been to court like 2 times, 3rd and on the 12th.
Oh, but y'all were put together, right?
Yeah. Me and Moonstone being that together, but Lil D, they got that nigga ass, I don't know. They be having him separate.
So what y'all heard like for what's the reason they would think you did something?
Shit, they keep talking about our 4 names will come common names keep coming up like on some shit like, oh y'all did it. Everybody like keep stressing like we crazy. They keep saying like we crazy, like we just unruly. Oh, that's so true. Oh, that got a nigga name on some crazy shit. Like nigga just.
That's all that is. We looking like I just explained them struggles. You know, they were just doing a lot of extra talking. You know, I had got there, got to throw it a lot on. So I'm like, I can't just vouch and say that a nigga ain't been beefing. But I said everybody had eyes on everybody when it was time when they said the boy got killed. Nigga had eyes on these folks. These folks was, you know what I'm saying, around a nigga. You know what I mean?
Yeah.
So how the hell they can leave in 10 seconds and go do shit like that and be like that around us all. You know what I mean? I'm like, shit. It is what it is. What the police do their job, man. You know what I mean? Yeah, I mean, just saying it because it was on some shit. Well, I told them nigga y'all outside something to do with it. Whoop. You know what I mean? And, you know, shit, I got there I had that, what the nigga name? I don't even know that name. He a lawyer. I had him just looking through it, just through the head going on. He like, man, so much shit just going on. He said, man, that shit real. He stay, she stay.
Yeah.
Yeah. So I was like, man, these folks, they'll be back with a nigga soon, man. You know what I mean? Fuck these niggas.
Yeah, the nigga thug shit down here. He was just like, he was just telling me, he was like, the shit that they saying, it like on shit like, yeah, I can go for it. I can say he had something to do with that. I can say
yeah, I can say that, this and that. You feel me? But he said, motherfucker not saying, I seen home do this. You feel me? So they can't say that anyway because, come on, bro, look at his name, they said.
Look at these there. I ain't never see these. You gotta see these fed, boy.
Huh? Yeah, that's
No, look, boy. I'm past the federal penitentiary.
yeah.
Man, they had like 18 marked out cars. Like, he didn't go bust them out of HSE, man. And never like, man, explode. Man, them folks deep as a motherfucker. They been go hit somebody in jail, hit somebody. They leaving out the federal penitentiary.
You have 1 minute left.
Man, they need to be hearing me, let me know what's going on, man. I be and that word about you, they be asking me about the shit I don't know, man.
Yeah, I be chatting. New baby tell me she be talking shit. I just be like, man, I be so down, bro. I be like, man, I don't want to talk, no. I just be.
I know, but you know,
down,
like I told a nigga, man, it's a process. Man, y'all coming home, man, y'all ain't did shit. That shit dead, man. And the nigga just so long. I said, yeah, man, I mean, you should have seen the date that they hit all y'all with. All the suckers come out to my they were there having it. Next thing you know, that nigga goddamn week, they pick their ass up.
Hey, new baby, somebody go to my shit. I wait on Santa get out. That's why they want new baby. I can't wait to get new baby. I wait on Santa get out. Nigga suck.
They came out leave about 30 days. That day they hit y'all with that shit. All the brothers and all.
Thank you for using Securus. Good luck.
And Your Honor, I want to make that correction. It was 10:45 until the end of the call at 16:05 instead of at 11:21.
They're talking about the case. I guess it's relevant.
Okay.
So the next call that we're going to play is November 19th, 2015 at 19:35. And this one will be played from 1 minute and 27 seconds to 9 minutes and 20 seconds.
Yeah, I'm gonna just wrote me said D said what's your number.
Man, fuck D, bro. Fuck them nigga, bro. Oh, just like that, bro. Fuck you. Straight up, huh? All that fake friendship, bro. Fuck you, folks. Wish I get on tour. Fuck all that pussy. I wish I get on tour. All these fuck niggas. Fuck all y'all rat ass niggas, man. Fuck that nigga, man.
I didn't know baby D on the phone. He said what happened to the SB in court because they just need more from charge. They didn't even take on the court.
That fuck nigga, you know what's going on. Pussy ass nigga.
Shit like that.
You a fuck.
Let's see.
Fuck you, man.
Okay. I said fuck D. He's not really talking to the test.
I just said, she just read it. It look like she run it.
You text me over your number?
Huh?
I don't got your number.
You only been him enough when you said, what you say? Some old shit now. What happened to baby?
That fuck nigga rat. They just went till I had went to court and they just let everything got. Tell that fuck nigga rat him and Wu and the other people. I don't keep going with folk. That fuck nigga know what's going on. Bitch, you in love with a rat hoe. Everything that came out to you. So I don't even qualify for that house arrest, 24-hour house arrest. Her shit. They say I don't qualify for a fucking bond.
Huh?
Say I don't even qualify for a bond. I can't even get a bond.
You said it in court.
Yeah. So I can't even get on house arrest. I have a 24-hour house arrest. Still trying to know. So my record, my history, bad.
Just so that I can ease the court's likely concern about this portion from about 450 on, we're not going to include any part about his bond and house arrest. But we're going to keep playing it just to get beyond that point.
So you don't know nothing about another court that name. That's going to be up to you when you get a lawyer.
Get on the 18th. December 18th.
Okay.
She'll be another time. Just run up. That's for nigga. But I want to slap that for nigga boy court, right? You got keep.
These in court with you?
Nah, somebody down. Take your ass private, turn that nigga, man. Take your ass lawyer, man. I want to slap that fuck nigga, bro. I want some lawyers that get out there eating them folks' ass up. I'm just like, bro, why the hell you ain't doing that, bro? Cause the shit they bring up, bro, that shit was just weak as fuck, bro. I'm some like.
Unless there is an objection, we'd also take out the part about the way that he wants to do his lawyer. But you know, we don't mind playing it, but I wasn't going to play that part, but it doesn't matter to us either way.
So there gonna be objection if they redact that part.
No objection.
All right. Thank you.
Like, eating their ass up.
Mom, do not leave her in here. This is not the time right now. Everybody get out. Everybody get out. Mom, can you get out too? Shut up. I'm not calling phone. You know what I'm saying? See, that's why I don't pick up my damn phone. People keep telling me that just shut and keep your head up. Here, a real one, for real.
That's all you hear. Oh, you're real. Man, that shit don't do nothing for a nigga. That shit don't make a nigga feel good. That shit don't do nothing for him.
I really get out this house.
I don't hear folk done brought up Duwop name, Nud name, Yak name. Okay, yeah.
Get that shit on me too.
Okay, Yak, Nud, Duwop. Oh, man. My head hurt, man. You out like that, baby.
I'm stopping at 9 minutes and 5 seconds instead of 9:20.
All right.
So, Your Honor, from what I hear, Mr. Stillwell is calling someone who lied on him a rat, and that's something I will deal with. I don't have any problem with that.
All right.
As far as 640, we have a complicated situation. I don't know how the state is going to try to play this, but there's a way to try to play this that would likely mislead the jury. I would hope that the state wouldn't do that. In 640, factually, Your Honor, Mr. Stillwell had been charged with this murder with Mr. Copeland.
It's not easy being the one everyone counts on to keep your operation running. That's why at Grainger, we're here for you with professional-grade industrial supplies and fast delivery. Call, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
County know that you have a prelim, and at the prelim, Yak and Duwop came up in the statement in the testimony about what other people were saying. So it is completely logical that he brought up Yak and Duwop there. However, if the state wanted to mislead the jury and not tell them about a prelim and not tell them about how Yak and Duwop were brought up in the prelim, they could try to twist this into something like Shannon's bringing up people that weren't even charged. But I mean, we're gonna, if we need to have 3 days educating the jury about how the criminal process works in Fulton County and preliminary hearings and all the rest to really complicate matters, to explain that to them, I guess we can. I prefer not to. But he's just recounting what was said at the prelim. So I would object. It seems like a simpler solution is just to take out where he's talking about Yak and Duwop at that time.
Judge, June 10th, I believe we are midway, if not further along in the Copeland interview. I believe that it's Mr. Copeland who is bringing up these names that Mr. Shard is talking about. I don't hear Mr. Stillwell talk about a preliminary hearing. I hear him say they're bringing up.
So this conversation is November 19th of 2015, right?
Yes.
All right. What you said something about June 10th. What are you?
Just that prior to that time that Mr. Copeland was the one who was bringing up these names.
Did anybody have a prelim
They all did.
on a couple of days before?
They did. And Mr. Sledge, as the state is very aware, in these other phone calls, there's discussion about the prelim, and Mr. Sledge's case was dismissed for lack of probable cause at the prelim, and the testimony or the statements made by other witnesses, including Mr. Copeland, was discussed at the prelim.
Okay, well, I mean, I don't know that you can tell from here where, what he's saying is somebody else let these names out. Somebody else is throwing these names about, and your client seems concerned about that, and that's relevant. I don't know that it's relevant how he heard that that was going on, but it doesn't sound like, I mean, it sounds like as long as they play the whole thing, he's saying, you know, whoever this is throwing these names around. It doesn't sound like he comes up with that on his own. He's talking about this other person is saying these names.
Right, but here's the dilemma. It's an unindicted case at this time. He doesn't have discovery. And what I am concerned of is the state saying, oh, wow, probably in closing, when I don't have a chance to respond anymore. Oh, wow, what a coincidence. Shannon Stillwell in that jail call is saying yak and doo-wop, even though they weren't charged at this time. That just proves everything. And the reality is those names were thrown around in the prelim days before.
All right, well, they may have been thrown around in the prelim. They may have been thrown around in interviews. Apparently, it's a whole lot of gossip that goes through the jail. But
Judge,
the state needs to make sure that they don't
we couldn't do that.
mislead the jury during the evidence or in closing with something that you know not to be true.
We agree with that.
Okay. All right, so this, it doesn't sound like there's an objection. It just sounds like there's some caution about how this might be used. And I'm telling the state right now, you better not use it in a way you know is not supported.
We agree and understand.
Okay.
My notes are clear. To recap, November 19th, the state is planning on playing 1:27 to approximately what time?
That was, Your Honor, 1:27 to 9:05.
9:05 minus reference to
The
bond and
bond,
criminal
yeah.
history and minus reference to wanting to slap an attorney,
That is correct.
who is not me.
Who once again is not you. All right.
The next call we'll play is November 23rd, 2015 at 16:08 p.m. from 8 minutes and 50 seconds till 16 minutes.
What your book look like? You straight?
Shit, I'm gonna have $6 on them.
So when y'all go back to court?
On the 18th.
And what they said, a hearing?
Nah, I just did the preliminary hearing.
So ain't nobody get no bond?
Nah, they tried multiple charge, cause multiple had a lawyer. They said the same thing about both of them. They tried all multiple charge. They did only thing different was the little nigga name, Deep Cleveland. He told me, I told him I did it. So they was, yeah, he said that's the only different thing. Then he just wrote multiple to my, man, oh God, bro, I ain't say that, bro. I go to court looking for no police lying on me, did that, third.
So multiple got lawyer.
Yeah, multiple got all this shit they missed.
So if you would have had a little, you would have got joined in this.
Hell yeah.
How much, what he paid on? I call my man.
Huh?
I call my man and see what's going on. You ain't got nobody else who you think give you nothing on lawyer.
Shit, I ain't called. But Kim just telling me got down to call him my knees on and shit.
Who?
Kim, I ain't calling it though.
Who?
Kente.
Kente?
Yeah.
Man, them niggas that be talking, bro.
Yeah, that's what I be saying. That's why I ain't really just put no effort. Like that fucking stuff was been sent the lawyer down here. That nigga, he keep coming down here, but he just like, shit, Doug keep telling me he ain't got all the money yet. Now fuck you, the money yet.
Who's saying that?
Oh, that was the lawyer. Like, the lawyer keep coming down here though, but he just like,
Yeah.
shit, I won't gonna represent you, but he keep saying Doug saying he ain't got all the money together yet.
How much they charge?
And this nigga, he ain't telling me the price. He just like, I told young Thor he gotta give me everything or nothing. It's everything or nothing. That's all he kept saying.
So he want all his money at one time. He don't
I
want
believe
down.
he's doing that. He's doing that because of Thor. You feel me? 'Cause he knows
Yeah.
home got money, so hey man, I want all my money.
You ready? Yeah, that's what I'm saying. Cause most lawyers, they do a payment plan, bro.
Yeah, exactly. Knew that top son lady, and she was like 4,000 some shit. She was
4,000 for it.
start.
Man, that nigga I had, he want that money, bro. Yeah, now nigga who beat my brother on murder case. You know, I'm cool with him. He don't even want that much. 4,000 start, that's too much.
Yeah.
I probably give him about 2,500. He probably put me on payment plan like every 2 weeks. Probably pay like $350. Right, what?
That's cool, no?
Mm-hmm. Hold on, sir. Yo, shit. Well, so what you got out of here? What you got now? What you got now?
Most of they got now, they got all them aggravated socks shit that they had. Aggravated socks, aggravated batteries, all this shit, them gun charges. No, they had
So what part of that truck? That murder truck?
Yeah, they just dropped the murder charge off him.
Man, that ain't shit. That's based on just like that.
Yeah. That's how he got like, you know, they got like 9 charges apiece.
That what they'll try to do, bro. Drop that murder and stack some on the aggravated stock. They're like 20 years.
Get what the lawyer said to me though. He was like,
what?
Man, listen. He was like, if everything go bad, he was like, you'll be looking at 20 and Mr. Schledge will be looking at life without parole. I said, God damn.
For real?
Musso, he was saying Musso be looking at life without parole. I said, God damn, why the hell you gonna do that? He like, shit, that man record's fucked up. Then the other choice he's facing. I said, good God.
That's what I'm saying. The aggravated stock charge and all that shit. That shit.
And that we need to say this part we would not be keeping in, the part about the sentence and the punishment for those charges.
All right, thank you.
Because I have from 12:15 to 12:40, there was discussion about likely sentences. According to the lawyer, whomever was advising Mr. Stillwell, apparently, according to him, this lawyer said, if everything goes bad, he's looking at 20 years and Muntuk's looking at life without parole. When you say we're not getting into the sentencing, we're including what Mr. Stillwell is facing, correct?
All of the sentencing for all of the charges, this portion that mentions sentencing, we would redact.
Okay.
Okay.
Still the same thing.
Yeah.
The murder, they just make niggas say, woof, these ain't got this. They got to fight that red stuff.
You know, that shit, they be better though, like that murder, you facing the murder charge and all that shit better because them folks telling on them, like, the nigga mama, she like telling them folks like, yeah, they did it. And then Lil D telling them folks like, yeah, home with me that night. And they said, Lil D already told folks he did it. And Lil D told him he did it when he left the club. Yeah, he told him he did it. And he told them that Monson was with him when he left the club. So they like, shit, if he with you, then he had to do that too.
You want to talk about that?
Yeah.
All right. No, no. Jose. Yeah, Jose. He taking pictures. No, the Fed.
Oh, yeah.
No, baby.
I told you she a private investor.
So we pull up. See, y'all talk. Damn, hey, how you doing?
I'm not gonna do about that.
Give her an oh Lord, she gonna say it. Why they? She gonna let her go down.
What you say?
Y'all talk. Pulled up. Oh Lord, she once told me it was new baby number. I'm like, I don't know that number. So that new baby, what you doing calling your phone? I'm like, Charlie? She checked. Really? Look. She thought she checked. You understand that? You seen Shawty go down there?
Yeah, you know, them folks would cook me and everything.
Girl.
You have 1 minute left.
They talking crazy.
They just talk shit. Well, he would talk shit. You just like, you know how niggas just shaking his head. And I gave you a young nigga over there. The young nigga was like, shit, I got down talking crazy with that little bro. But shit, you know, nigga Ryan, shit, them niggas just talking about, hey, guns up. Shit. Yeah, guns been up.
Girl.
Yeah. I ain't stunning on niggas, man. Fuck them.
Yeah. That's my the Wu said something too, then.
Yeah.
Nigga say anything, try to say they ass, but.
Yeah. So you know, that shit be having me down, but I just really be shaking that shit.
That's what I'm saying. That shit be crazy. You be with a nigga 380 days, 180 days, whatever. 2 years, 5 years, and situation pop up, and you're like, boy, he did. That be fun. That one be me.
Exactly.
The nigga sit right there.
Thank you for using Securus. Goodbye.
Call. Oh, wait.
On this call, there is extensive discussion about the issues Mr. Stillwell is facing hiring an attorney. I don't believe that that should be relevant. That's A. Regarding 1315, approximately at 1315, as I hear it, Mr. Stillwell is saying that Mr. Sledge told him that someone, and I think it was Lil D, said that he being Sledge was with him during a separate incident, which I believe to be the 428 incident shooting up houses. But in that segment that starts at approximately 1315, we have Mr. Stillwell passing on hearsay from Sledge about what Lil D supposedly said about Sledge in I'm not going to say non-related because it is on the indictment, but non-related to, it seems, the Donovan Thomas case situation. So that seems to be hearsay wrapped into a statement by my client. I don't believe that that should be admissible. And that's 1315. I don't have an end time. And then quite frankly, after 1315, there seems to be a lot of kind of laughing and giggling that don't really have a lot of relevance to anything that I can ascertain.
Okay. So we've got the discussion of the lawyer, the kind of hearsay from what Lil D said, and then the sort of end of the call. Sorry. Yep. I just was summarizing what Mr. Sharp said. Okay.
What I heard in the court summary was the discussion of the lawyer, the summary of what Rudy said, and then the end of the call.
Right.
Okay. So in terms of the lawyer, as I said earlier, with respect to what the lawyer is saying about sentencing and all that.
Yeah, no, I know. We all know that's out before that.
But the part about defendant William, or Thug, as he puts it in the call, getting him a lawyer, I'll point the court's attention to over Act number 97, wherein there is in the lyric of the song Just How It Is, the assertion gave the lawyer close to $2 million. He handles all the killings. We don't speak about shit on wax. It's all my business. We know how to kill the biggest cats of all kittens. And so our assertion would be, considering that Mr. Stillwell is discussing a lawyer who has been sent down there to talk to him by defendant Williams, and that he wants all his money up front, that could be, their inference could be made by a jury reasonably assessing the evidence that this is part of the proof for that particular overt act. It's not just in a vacuum discussion or negotiation with the lawyer. It's who's providing him the lawyer, what it is the lawyer is asserting that he wants.
Okay.
So that's our basis for the relevance of the portion about the lawyer.
All right. I agree that's relevant, and I don't see a 403 issue with that. All right. What about the kind of hearsay reporting that Lil D says, or kind of admits to have done it, and that Monk was with him for one of these other?
It goes to show the level of awareness within the jail by defendant Stillwell of what other people were saying, and the fact that Lil D swore to God the police lied on him. It would help explain. I don't know what, and I think he's actually talking about Garlington, but it was Quindarius Zachary was one of the people that told that he and Mr. Sledge committed the April the 28th shooting on Adele and Drew Drive. And to the extent that either one of YSL members, Shannon Stillwell himself or anyone else, confronted him about telling, the fact that he's asserting, I don't know what the police are talking about, they're lying. It speaks to this culture of you're not supposed to snitch, and the fact that they know that they're snitching. If there are changing stories, it would help the jury understand why stories get changed when witnesses take the stand, in particular the witnesses that we expect will be called, and frankly, one of the witnesses that's already on the stand now.
All right.
I believe that what Ms. Love is using to defend that portion is not in the portion that I'm seeking to omit. There's a discussion about Lil D told, and then he swore to Sledge that he didn't tell and the police are lying. Okay, that's not what I'm talking about. At 1315, there's a discussion about Sledge saying that Lil D told on the 4/28/15 shooting, told on Sledge. It seems to me
that's a co-conspirator statement. Sledge telling him, or if he's discussing that Antonio Sledge is bemoaning the fact that Lil D told, he's apprising him of the fact that someone's snitching, on a member of YSL.
Well, we just changed the verb. He was bemoaning and now he's apprising. The bottom line is he was bemoaning, it sounds like to me. He was bemoaning the fact that Lil D told on him on something that Mr. Stillwell is not charged with. So I don't know how that's relevant.
The fact that the information is getting passed along through members of the gang to other members of the gang is what we believe is the most relevant part of it.
Mr.
And it explains, it's defendant Stillwell's assertion, his asserted knowledge, and it explains people's behavior when they get in the courtroom and tell God's honest truth.
Okay.
Mr. Stillwell in these calls makes it clear that he's being transported to all his court dates with Mr. Sledge. That's not a mystery. The state puts him in the same bus, and apparently, I'm not denying that Mr. Sledge would have probably talked about things going on in his life to Mr. Stillwell, but this is a completely unrelated incident that Mr. Stillwell's not charged with. So
Well, he sort of is based on the RICO count. I mean, I don't know that he knew he was going to get charged with RICO at the time, but
let me just add this.
So I have an idea. Why don't we just ask people what they want?
These mushrooms make you feel better. Like
Mr.
okay, do not come back in here with that if that's going to go off again.
Mr. Stillwell, Mr. Sledge and Mr. Garlington pled guilty to this
Right.
incident. So
Okay, and
Stillwell, Mr. Sledge and Mr. Zachary, I should have said, pled guilty, and Mr. Garlington.
right. And so how is it a co-conspirator statement, I guess, is, I think, the gist of, are you just saying relevance or are you saying something beyond that?
The state is always saying to in furtherance of the conspiracy, and I'm just failing to grasp how Mr. Sledge bemoaning about that someone's telling on him is in furtherance of any conspiracy.
Okay, so yeah, that's the issue on the floor.
So it's the statement of Shannon Stillwell about what Mr. Sledge has said, and it's showing Mr. Stillwell's awareness of what is happening with other members of YSL and these charges that each of them are facing.
Right, and how is Sledge's having told him that in furtherance of the conspiracy?
Well, letting one gang member know that another is telling on them is letting that other know and to be aware and wary of, as that other also told on Shannon, let them know and to be aware and wary of that person ratting and telling the truth on the gang itself. It's apprising them of something that may harm them.
Okay. All right, I'm going to let it in under the co-conspirator exception. All right, and then there's the part that's sort of the end. Is there anything relevant in that part?
Not beyond the part where he's not at the very end. There's a little bit, and when the court says the end, I'd have to go back because I think I played it.
Well, I guess
already.
everything after that little part is about the, what Sledge says about Lil D saying. After that, is there anything? And there may be.
Let's see. Hang on one second.
Sure.
I'm checking my notes. This is it right here. I see. My recollection is there's not, but to be safe, I can just start at the about a minute before the end, replay it.
I would ask if we could start at 14 minutes because I believe there may be something.
We're starting at 13:35.
Him when he left the club, so they like, shit, he with you, then he had to do that too.
I don't even want to talk about that.
Yeah.
No, no. Oh, yeah. He take pictures. No, the shit.
Oh yeah.
New baby.
I told you she a proud investor.
Hey, so we pull up. See, y'all talk. Damn, hey, how you doing?
I'm not gonna do it like that.
Give her an oh Lord, she gonna say it. Why they should I let her down?
What'd you say?
Y'all talk. Before we pulled up. She said, oh Lord. She once told me it was new baby number. I'm like, I don't know that number. She said, that's new baby. What you gonna call your phone? I'm like, for Charlie? She checked it. Look. You thought she checked. Now I'm saying that, you seen Shawty go down there.
Yeah, you know, them folks would cook me and everything.
Girl.
You have 1 minute left.
They talking crazy.
I didn't just talk shit. Well, he would talk shit. He just like, you know how niggas just shaking his head. And I gave you a young nigga over there. The young nigga was like, shit, I got down talking crazy with that little bro. But shit, you know, nigga Ryan, shit, them niggas just talking about their guns up. Shit. Yeah, guns been up.
Girl.
Yeah. I ain't stunning on nigga, man. Fuck them.
Yeah. They took my the Wu said something too, then.
Yeah.
Nigga say anything, try to say they ass, but.
Yeah. So you know, that shit be having me down, but I just really be shaking that shit.
That's what I'm saying. That shit be crazy. You be with a nigga 380 days, 180 days, whatever. 2 years, 5 years, and situation pop up and you're like, boy, he did. That be far. That's why I'm talking bro.
Exactly.
The nigga sit right there.
Thank you for using Securus. Goodbye. Hello, this is a prepaid collect call.
So to answer the court's question regarding the portion after that snippet, there's a minute of between 14 minutes and 15 seconds and 15 minutes and 15 seconds that we do not need to play. Starting at about 15:15 and going down, we think that that portion is necessary to play. It entails a couple of things. They're talking about Woody telling, they're talking about, the little N saying guns up, and I'm saying guns stay up. We believe that that's a reference to Peter Rolak, sex, money, murder, Bloods. So for that portion, we believe it'll be relevant.
I mean, those seem relevant. That other part in between, you can redact out.
Yeah, I don't know what the state's talking about with the guns way up thing, but I would ask that the last minute be played.
I'm sorry, you would or you would not?
I would.
Okay. Got it. I think they will. Right?
Yes.
Okay.
That's what we were saying. From 15 minutes and 15 seconds to the end.
Okay.
We were playing that.
All right. Let's move on to the next part. for the next call.
The next call is December 4th, 2015 at 15:48, starting at about 11:57, but we'll start at 11:30 to be safe to give context.
But saying no 2 weeks, we don't wait on no $300, man.
That shit, wait, no fuck, man.
And these folk off me 5 and 2 yesterday. Man, you think I'm finna go? I ain't doing no time. I got fun out, man.
Not be playing that part.
What the fuck? Man, like, fuck out that jail, man. Then these niggas with their fuck shit yesterday at court. Nigga trying to jump me, man. Fuck these niggas, man. Oh, I said, fuck a YSL. I ain't finna go ahead and fight for no fucking YSL. YSL won't even bond nigga ass
I want to fight for their ass too.
This is not my client.
I swear I was finna go in there and get beat shell Carol ass, bro. Straight up, I'm telling through the gas bone, everything, bro. I'm like, nigga, what's up, then, nigga? Nigga, I don't give a fuck what you talking about, nigga.
Is it ever gonna be?
No, it's not. In the beginning of the jail calls, it says who the call's from. These are from a gentleman named DJ. I don't know why the state believes it's my client. It's not, though.
We'll verify before we would speak to Mr. Sharp. So we'll hold on this one.
Okay.
My stance isn't changing. It's verified.
We understand his position. We'll look at it again, and if we feel differently, we'll bring it to the court's attention. But right now, we're not planning to play it until we look at it and reassess it.
All right, was there another one?
There is. This will be December 4th, 2017 at 17:31.
Do you mean 2015?
No.
You said that before. Is there one of them that's from 2017?
Yes.
Okay.
I know.
Let me make sure we didn't label that wrong.
If it is 2017, it is definitely not my client on jail call.
It would be kind of odd for it to be.
It was a
between
typo.
two other December
It was a typo.
2015 calls.
It was, I'm sorry, it was a
Okay.
typo.
2015.
Yes. And we're gonna go from eight minutes and 10 seconds to 8 minutes and 30 seconds. It is, for the court, it is December 4th, 2015 at 17:31. And it is going to be from approximately 8 minutes and 10 seconds to 8 minutes and 30 seconds.
Thank you.
That shit on there. Stop, shit. Yeah.
But I still want to add one question though, about is y'all fucking with
Who?
you? You know what I'm talking about.
For me, then?
No.
Who?
Oh.
You to my, him.
Mm-hmm.
Yeah, he want to pay for everything.
Oh, okay. You're right.
Judge, that's a short snippet of the call. We believe that the him that he's referring to is the same person that he referred to as providing or sending down a lawyer earlier. That would be our argument for it. If we need to, there's an argument that we need to play additional portions of the conversation by Mr. Sharp.
I mean, is there some context either within this call or what's going on today or something that leads y'all to believe that?
The only context, Your Honor, is that prior to that exchange, and I'm not representing that it's immediately prior, but it is prior in the fact that my notes, one note before this is Shannon says he had talked to Kente. Kente, as it has come out, I believe it's come out in this case, is the owner of Club Lacura, Lacura, which is on Metropolitan Avenue. So that was, I'm just saying, on my notes, that's the note right before they say, is Shorty effing with you? So I know what the state's trying to insinuate, that Shorty is Jeffrey Williams, but no, there's no context that suggests it's Jeffrey Williams. And what I'm saying is, according to my notes, there is some context that suggests it is someone else.
I'd like to play 7 minutes and 29 seconds.
Hey, too much.
Yeah. I love you, boy.
Man, come on, man. You know what's up. Don't nobody know what's up. You know what's up.
Oh my God. God, I bless my heart back in my life.
Yeah. This shit gonna be over, though. Real soon.
Oh, you gotta come home. We gotta get on the real grind. We gotta get on the grind.
That's how I've been telling him can't take everything. He like, man, what the hell? How the hell you get into that shit? Like, you know how this shit go, man. Stop, shit. Yeah.
But I still want to add one question though, about is y'all fucking with
Who?
you? You know what I'm talking about.
For me, then?
No.
Who?
Oh.
You to my, him.
Mm-hmm.
Yeah, he want to pay for everything.
Oh, okay. You're right.
I was saying, you my bitch, my nigga.
Man, I don't care nothing about no hoe.
Yeah, Shawty, you doing all right, though?
Yeah, I'm gonna be hungry like God. I ain't gonna never stop that. You know that's how we all told each other.
Yeah, exactly.
I love you though, man.
I love you too.
Home.
Huh?
I want you home. What we got?
So, Judge, what I did was
They're talking about somebody else when they start that conversation. Because at first he's like, oh, who do you mean? Oh, you mean him. So they're not talking about the person they were talking about a minute ago. Now, it's an argument that the state's going to have to make. Sorry, it's an argument the state's going to have to make. I don't know whether the jury's going to buy it or not. Y'all can argue differently. But I mean, I think it's certainly a reasonable inference. So I'm going to permit that.
Thank you. The next call, the last call that we have, outside of the ones that we have just said we're not going to do for now,
all right,
is the December 7th, 2015 call at 16:55 from 1330 to 1600.
man. I don't even know what fuck nigga money. They be having their ticks. I know that like shit. I have an ear hustle from yesterday, right? So you remember when the nigga got on the phone? The blood nigga got on the phone. You remember when blood nigga got on the phone? He was when we called Bull, Joe Shot, all them niggas.
Oh, okay, what's yesterday shit, yeah.
Alright, so you remember when he was like his big home name Montana? You might don't, but he was just like his big home name Montana.
And you run Rush Street.
Yeah. I'm not thinking this nigga Montana is the same guy I got rolled with like you ask me who just at Willow with me, like that Bull just be like, Bull, what the hell? Like, anyway, he was just like running behind me at Willow, like you feel me? Like I had like then I just when he came in here, he was like, hey yo, HB, why who the hell that is? Like it's Montana, bro. He ran from a dope, showed his face and ran back to his room because they were telling him to go in his room. I was like, swear Montana, these young niggas up on you. He was like,
You have 1
yeah.
minute left.
He was like, yeah. I said, man. I said, you got these little ass niggas pushing up on me like that, bro? He's like, man, look, bro, I heard about that shit. I was telling niggas like, you my personal, this, that. I'm like, yeah. But this shit crazy. But like, okay, but I was ill hustling yesterday, and the nigga who I was telling who was slick, Hank, downstairs, he pushed up. When I was like, man, these niggas being like fit, these niggas some hate, these niggas hate, these niggas be throwing YSL pointing at my door.
Oh, yeah.
All right, he walked over there to my challenge door, like they know each other on the street. So I guess he was just talking. And I just heard my name. Now I just heard LeBron. And I heard my challenge say, man, that's not personal problem. Anything went home, I'm going to hate shit about it. So he like, yeah, I fuck with bro. He here real right nigga, but I feel I be sick.
Thank you for using Securus. Goodbye.
This just seems like a recap of the whole Montana situation. They're just rehashing the jail call that the state's already going to be playing. If Your Honor is going to allow this in over my relevance and cumulative objection, there is a point where Mr. Stillwell says something to the effect of, I knew him from when we were down the road. That is common parlance and for being in prison, and so that reflects on my client's character.
Okay. We agree that would come out, the part about prison or being down the road. And with respect to the remaining portion of the call, is the reference to throwing up YSL in the context of that similar call as the other one. That makes it different and a little bit more.
I mean, there's a specific mention of YSL, so I don't think that is cumulative based on that. So I'll admit that.
And Judge, there was one more call. I said this was the last one, but there was one that we passed over.
Okay.
It is the November 18th, 2015 call at 1843. I don't believe that we played it. I think we referenced it. Okay.
We gated that yet.
Okay.
I'm Donald J. Trump, and I approve this message. The alarming spike in inflation soaring to its highest level in nearly 40
You. You.
Your neighborhood rolling 60 cars? Ain't nothing. You rolling 60 neighborhood? Your neighborhood rolling 60 crib cars? Huh? You what? What is she like? Hello?
You need to stop playing with people.
What?
I said you need to stop playing with people.
Neighborhood rolling 60 cars? What? Yeah, right. We the second fish. We the first. They work. Yeah. Sunny side the fuck up, son. Shine up and line up. Straight up and lay up. Yeah. You know, it's always a shine to the nine, though, you know? Shine to the nine, my dude.
Yeah, need shit. Oh. Oh my gosh, this was just do for you tonight.
We went to 434, but it was really 428 that the call stopped at. And that was just from about 320 to 428.
Is that the entirety for that call?
That's the only part that we were looking to get into.
I don't understand the relevance. If it, yeah.
What's the relevance and how is it not cumulative?
The first call with respect to Shines and G Shine and the defendant Stillwell was dealing with his blood credentials. This call shows him interacting with who he believes is a Rolling 60s Crip. Martinez Arnold is a Rolling 60s Crip who we also allege is a member and who has pledged to being a member of YSL, the criminal street gang. During the course of this trial, there have been repeated efforts on cross-examination to disprove the state's assertion that YSL is a criminal street gang.
And that it's hybrid?
Yes.
Okay, so this goes to that?
Yes.
Okay. And I will allow it. All right, that's it for these. Sorry, Mr. Harvey, that's it for these this set of jail calls?
Yes, for Mr.
Okay, for
Stillwell.
Mr. Stillwell. All right, let's take a break. Not quite sure what we're going to tackle next, but something. All right, let's take 15 minutes.
Kamala Harris is the advocate we need. As president, she will defend our reproductive freedom, protect Social Security and Medicare, and ensure our children can be safe at school. Kamala Harris, for our freedoms, our families, our future.
School is back, and Dick's Sporting Goods has what you need to win your year. Check backpacks off your list from
Several folders. We appear to have two for Mr. Arnold, Garlington, Kendricks, other items, and then some, I don't know, pictures and things. So can we move through them methodically? There's a recording in Mr. Arnold's. Is that what we've already gone over? Is there anything we need to take up that we haven't already dealt with on that? Okay.
Not with that I've.
Okay. How about in Mr. Garlington's folder? Is that his statement?
Your Honor, the item in the Garlington folder is a jail call.
Okay.
And to make sure. At this time, I don't believe that jail call will be able to come in.
Okay, so state does not intend to use that. All right. And now I've lost my place. Well, what was next? Because I have no idea where I was just looking at has gone to on this computer.
So I think the next folder, Your Honor, is the folder that says Diamante Kendricks.
Okay.
And there's 3 jail calls in that folder, Your Honor.
Maybe that's what happened to me too. It just went poof.
Ms. Hilton?
Yes.
So just so I'm clear, we're talking about the other folders in the sprinkle folder that have other people's names, correct?
Yes.
Can you give me a minute, Your Honor, because I can't get the courtroom Wi-Fi.
Okay, and you know what? I think we've maybe got access to some sort of a Wi-Fi router or booster that Ms. Persfield's going to go try to get right now, so that, because I'm not really sure why Fulton County can't provide stable Wi-Fi in the courthouse, but it's a continual problem. So let's see if we can get a router or whatever it is. Not very tech savvy, so I don't know what the right term is, but something to help us. Thank you. All right. Now, there are 2 different Arnold folders. Do they contain 2 different things?
Yes, Your Honor.
Okay.
One folder is the interview that we talked about a couple of days ago.
Right, okay.
And then the other interview are 4 jail calls.
Okay. All right.
That will more than likely, he is expected to testify, Your Honor, and so we would use these primarily for impeachment purposes.
Okay. All right, so we probably don't need to take those up right now.
Well, all of it, I guess, the 4 in the 4 jail calls, as well as the interview, would only come in for impeachment purposes.
All right, what's in the other items folder?
looks to be a Justin Cobb. It looks like a social media posting. It is a social media posting of Justin Cobb. So I'm not sure if Your Honor you can't open it, I think.
I could open that, or I can see a little thumbnail of that one. Is that something the state's gonna be using? Could you put it up on Zoom maybe? I don't know. Is it working for y'all?
As of right now, yes, Your Honor.
Okay.
I'm not sure if you have access, Your Honor, to let me in the Zoom room.
How does, is it like exclude people once Wi-Fi goes out or something?
Or sometime at lunch, it'll kick me out at lunchtime.
Don't know why. Okay.
Judge, this is on the screen. If you have,
Mhm.
can you see it?
Yes.
So that is the posting that is in the other items folder in
Right.
Mr. Sprinkle's folder. And the purpose of it primarily is to show the phone number that Mr. Cobb uses at that time.
Okay. And any objection to that?
So, and maybe I need a bit more clarification. I understand it's a posting ostensibly by Mr., I don't know if it's by Mr. Cobb or not. And if they're indicating that he is the one who's posting that phone number, and how that's, if there's information to verify that, separate and apart from this posting.
We would be having the person who found the post and who can talk about what they do, provide a foundation for it, like we would any other social media posting. Whether the jury believed that we have that right would be a matter for, I guess, argument. But we believe that based on what we were able to find, that this is Mr. Cobb's phone number. I think Mike Sprinkle is the one that actually found that posting. And he's free _ doo-wop. And he's responding to @Stunna Bumpkin with his phone number.
It's hearsay, Your Honor.
How is that not hearsay?
It's
because that is being offered for the truth of that being his phone number.
It's how we were able to.
Are you offering it to establish that that 678 number is the phone number that Justin Cobb / doo-wop was using at the time?
Yes, and we would not need to put that particular picture up as long as the witness is testifying how, he
The
came about
witness
it.
being Mr. Sprinkle?
88 Sprinkle, so he wouldn't just have that showing that it was his phone number. He would have other items of evidence to show that lead us to believe that it's his
All
phone
right,
number.
what would those other items of evidence be?
I believe that we got his records, his phone records, so who the other
Well, then
calls.
That would be the way to show it then, through his phone records.
Right, so when he's doing the deep dive into who did what and how we are able to find out who is where, he starts out trying to get phone numbers for people. And this is one of the ways that
do we need to know that this is how he got it, or do we just need to know?
not necessarily, it's not one that at this time I think we would need to put up. It's just one that we had.
Okay, well, I would think that if there's some reason we need to hear from either Mr. Sprinkle or a phone records custodian, that this is the number for Justin Cobb.
And
that-
also, Ms.
Go
Hilton's
ahead.
reminded me, we had a number that was being used by another person who was being called. So these jail calls involved calls made to Javaris Bradford. And there were other numbers in his phone logs and in other co-defendants' phone logs. This was one of them. And again, it's going back to the fact that he, in an effort to find out who this number belonged to, I think that he, in searching social media, came upon
Okay.
this.
Well, I mean, it might be kind of cool that Mr. Sprinkle is good at finding nuggets in social media, but I don't know that that's relevant to this trial. If this person's phone number is relevant to this trial, then establish that through the certified copy of his phone record showing that this is his number, okay?
Yes, Your Honor.
All right. All right, Mr. Weinstein, were you able to do what you needed so that we can go over Mr. Kendrick's jail calls?
Yeah,
Or-
I'm just using my phone. 'Cause I can't
Okay.
go on the Wi-Fi here, but
Okay,
I'm almost there.
Okay.
Give me a 5
okay, no problem. All right, how about the other, like, what look like maybe individual pieces of evidence? There's, I don't know, the one that's labeled CKNQKS, whatever, that's a picture of somebody standing by a car. Is there any objection to this picture?
I think first we'd like to know from the state what it is they believe it purports to show, how it's relevant, and
Okay,
we can respond.
Your Honor, really, this is a picture of Javoris Bradford, who is one of the individuals that we've alleged had a part in, as a party to a crime in the murder of Donovan Thomas. And specifically, Your Honor, we believe he's the driver of the Bonneville vehicle initially while they were at the Texaco gas station. And this is a picture of Mr. Bradford in front of what we believe to be that same Bonneville.
okay. At a different time.
At a different time.
Okay, that seems relevant. All right, let's move on to the next. Color copy of Sprinkle report. Y'all are gonna
Is in the
use that,
Sprinkle
that's
rep-
just
right.
giving that to them for, okay.
Right.
Very good. All right, then I guess we've got some more images, maybe?
Next few are again of Mr. Bradford at different times with that same Bonneville, just in case there was.
Okay, is that what all four of those ones, next ones are?
Except for IMG _03901, that is not.
Okay,
That one is the Infinity after it was sold at auction to the person,
okay,
the next owner of it.
all right, and then is the last thing just a duplicate of that?
One's a distant shot and one's a close-up, Your Honor.
Okay. All right, any objection to any of those?
I don't believe on behalf of the board.
All right,
No, Your Honor.
okay,
And of course, for the record, Your Honor, we would take off the comments off of.
thank you. It's working on mine, but Mr. Weinstein might need it. I think I'll just leave mine alone. Our new Wi-Fi router passcode, just let Ms. Persfield know. I should try to email it to y'all, but in case you're not getting email.
Okay, Your Honor, we're ready, but I believe the issue with Mr. Kendrick's jail calls It's only the first call, and Mr. Adams is going to speak.
Okay, perfect.
Thank you, Judge. So we've got three, what appears to be three calls, jail calls here for Mr. Kendrick. The first one is a call that occurs on October the 4th, 2015. I'll just go ahead and set it up because it's an issue that's similar to the issue we dealt with Mrs. Stillwell earlier. On that phone call at about the 2-minute and 50-second mark, there's a conversation between Mr. Kendrick and his significant other, someone named Tasha. His mom, well, yeah, she's significant to him. His mom, Tasha, is a conversation about an attorney. I believe my recollection, if my recollection is correct, Mr. Kendrick says something to the effect of, I've got a lawyer or getting a lawyer. And Tasha says something to the effect of, Thug is working on an attorney for you. So number one, same objection as before. I don't believe it's particularly relevant. There has been an association shown between Mr. Kendrick and Mr. Williams. And so the fact that there is some discussion about whether or not Mr. Williams is going to assist him in getting an attorney, I don't think it particularly proves anything in the case other than what the state intends to argue, obviously, as they've said before. And it bears noting that he does not get him an attorney. There's no evidence, there's no factually, it doesn't happen. He never maintains and gets an attorney for him. No attorney ever comes to see him at the behest of Mr. Williams. So I just don't think it's helpful to the jury in any form or fashion in regards to these charges.
All right. Ms. Hilton.
Yes, Your Honor. I think for the same reasons, Your Honor, it is our contention that when Mr. Kendrick is in jail following a fleeing and attempting elude, but when they are actually intending on going up to shoot up the opposition's home, they get stopped at a roadblock, but they were on their way to shoot at the opposition with a number of guns in the car. They then take the police on a high-speed chase, and he's subsequently arrested at that point in time. This call is important for that reason. Is the state's contention that when YSL members get in trouble, they reach out to Mr. Williams and he provides attorneys. Whether or not the attorney comes or not, it is the fact that they believe he's going to provide them assistance. But what is more important in this call is what happens after that. So Ms. Tasha on the call says, Thug is going to work on getting you a lawyer. And Mr. Kendrick says to his mother, don't say his name, say bro. And what we have found consistently throughout this case, and we'll believe the evidence will continue to show, is there is an effort to conceal his identity, conceal Mr. Williams and who he is. And so they never reference him as Thug, oftentimes on jail calls, but it's bro, slime, or different other terminologies. And so that is also what is important with this call, Your Honor.
All right. Thank you. I'm going to admit it over objection. And obviously, if y'all want to cross-examine the right person or put somebody on the stand to say he never got him a lawyer, that's up to y'all. All right. So was that the only of the jail calls?
Yes, Your Honor.
Okay.
Of those three.
All right. Thank you. So then I think we've taken care of everything in the sprinkle folder at this point.
Yes, I believe so, Your Honor.
Great. Okay. So then I think that also means we've taken care of everything in that whole entire 1 through 30 witnesses.
Yes.
Let's pat ourselves on the back. All right. We can move next to, don't we have this same thing for 31 through 60? We can move to that, or we can move to the wiretaps, or if there's something more pressing, y'all tell me. But we're not going to waste this time we have without the jury getting stuff done.
31 through 60 would be more pressing before the wiretaps, Your Honor.
All right, let's all find that one. And is that a different Dropbox link? Can you remind us what the email would be for that one?
Yes, Your Honor.
Thank you.
The initial email was August 12th, Monday, August 12th.
Okay, thanks.
Yes, Your Honor.
Your Honor, for the box 31 through 60, Mr. Ryan has 31 through 35, and that's the one we're discussing with the state in the background.
Okay.
So we're still working on that.
Okay, so 31 through 35 set aside for now. Okay.
Working on that.
All right, that's fine.
The next folder says 32 through 39. And there's only one witness in that folder, it's Officer Rogers. There's nothing in his folder, so we can move to the next folder.
Okay, I don't actually, I'm still waiting on the email, but
So am I.
You got it. Okay. Thank you, Mr. Weinstein.
well, I know it doesn't come directly to me, and Miss Pershfield's downloading everything now, but that's fine.
It hasn't come to me either.
Feeling Claritin Clear is like
Okay, go ahead.
So we can start where it says counts 3 through 7, Your Honor, that folder, Acts 88 through 90, armed robbery, Dewan Maynard.
Everybody ready?
We are.
Okay. We're gonna just start with the Colin Russell folder that's in there. Ms. Hilton?
Yes, sir.
Okay. And are these videos or just images?
There are videos, there's portion of the surveillance video from
Okay.
the night of the armed robbery.
All right. And does anybody have objection to any of these 3 videos?
Not for Mr. Huey, Your Honor, as it relates to these videos. I assume that it's going to, proper foundation will be laid to get them admitted.
Anybody else?
Nothing on behalf of Mr. Williams.
All right. Nope, nope. Okay. And then that last one looks like it's maybe a cell phone. Is that a video of something being shown on a cell phone or what's that?
Yeah, let's look at that. Yes. It is a video, Your Honor.
It's a video from, we're alleging it comes from Mr. Huey's. It's someone taking a video of Mr. Huey's Instagram page.
Okay.
So we will lay the proper foundation to get it in.
Okay. Any objection, assuming proper foundation?
Understood.
Nope.
No objection, assuming proper foundation.
All right. Let's see what's in our next folder. Joel Hines.
There's nothing in his
Oh,
folder.
you already said that, didn't you? Folder number 38, Mr. Maynard. A lot of images. Everybody take a second and look at those and let me know if there's any objection to any of that.
Your Honor, with respect to the second photograph on the first category, on the first line of photographs at the top, the second photograph to the
It's like
right.
the hand and arm.
Yes, Your Honor.
Okay.
I'm not sure. The Instagram says Hunchoke K, HUNCHOKAE. Maybe the state can talk to us about foundation for that.
Yes, Your Honor, that is the picture of the victim in his hand. That's the picture that the victim provided to us to show that those are his items that were stolen from him during the armed robbery.
Okay. With that information, any objection?
So just so that I'm clear, my understanding, Your Honor, is that this is not the alleged victim's Instagram account. So I guess they'll have to deal with that if they call them.
I mean, not really, because what they're offering it for is to show that these were the victim's items that got stolen.
During the
So
armed
it
robbery,
doesn't really
yes.
matter where the picture came from. If he can say that's my arm and that was my ring and my bracelet.
We believe we have a different understanding of who the
Okay.
photograph that is, and we'll deal with that at trial.
Oh, you think that's not his arm?
That's-
Is this victim going to testify?
Yes.
All right, well, we'll see what he testifies to. But it doesn't matter whose Instagram it came from. If is going to testify that those are his items, I assume on his arm. I don't know. We'll see. Okay. All right, any of the others? We have lots of pictures of, I guess a lot of jewelry got stolen, maybe.
Yeah.
Your Honor, I don't know. Obviously, the state has to present their case as they see fit with respect to all of these photographs. However, I do think a proper foundation would need to be laid for several of these photographs. So there may be some real-time objections as it relates to them, Judge.
Okay. Understood.
Okay.
All right, other than that, then I guess we can move to the next folder. Mr. Jenkins, that's also empty. Okay, Officer Suk.
Yes.
So he's a crime scene check.
He was the responding officer, Your Honor.
Responding
So we,
officer.
in order to cut down witnesses, we're going to bring in the crime
Alright.
scene photos from him.
All right. Any objection on any of that?
Subject to foundation.
All right. Then we've got Officer Francis. And what have we got there? Any objection on any of that?
It just appears to be more photographs of the same that were contained in another folder.
Yes, Your Honor. We put the items in places where either of those witnesses could
Okay.
introduce the
All right.
evidence.
All right, and then we've got Officer Greer.
Your Honor, I believe that this particular piece of evidence pertained to the motion in limine that we dealt with on yesterday that I believe was excluded, if I have that correct.
No.
No?
So Mr. Huey was arrested in 2020
Okay.
for this incident initially. And when he was arrested along with his girlfriend at the time, Miss Justice Woodard, and he gave a false name back when he was initially arrested on the armed robbery warrants. And so this folder deals with the officer who arrested him on those warrants in Fairburn, Georgia.
1 second, Judge.
All right, sure.
This folder here.
Mr. Huey has 2 armed robberies. This is the 2019 armed robbery. He was arrested in Fairburn and gave a false name on the 2019 armed robbery. I'm sorry.
Judge,
Yes.
I do have a question for the state concerning the video that is in this particular folder. I don't believe this video pertains to Mr. Huey's arrest.
All right.
Says female search.
There's 2
That's the-
videos, Your Honor. I think
Go ahead.
on the night they both were searched. So I think it's just the body cam for both of.
Are you planning to show the search of the girlfriend?
No, Your Honor.
Okay. Is that the only one you had objection to?
This is not the girlfriend of Mr. Huey, according to this particular piece of evidence that, in other words, this person that's being arrested is not associated with the arrest of Mr. Huey. That's our position.
The one that says female search or the other one?
That is correct, Judge.
Which one?
Oh. The one that says, one
Okay.
that says female search.
All right, well, they don't plan to use it anyway.
Correct.
Okay.
Okay, so that's excluded.
All right.
Okay, thank you. 1 second here. Which one were we?
Thank you. All right, so then we've got the AT&T records custodian. There gonna be any issues for that witness?
Just subject to the foundation, Judge.
All right, and then we have Miss Latner's again, and within her folder, we've got, I guess these are new things that we didn't look at in that first time around earlier today.
Yes, Your Honor.
Okay.
In order to try to reduce the amount of time Ms. Landers comes back, when she comes up at this particular
Sure.
time, we're going to try to enter in a few different CADs.
Okay.
911 calls.
All right, and has everybody looked at those? So if you've got any kind of objections like we had this morning, you can raise them. Although I've got to say, pretty much all of those things we went over this morning are kind of evidence 101 that you'll ought to be able to agree to. Not saying you have to, but any chance y'all might take this next group and see if there are actually some legitimate objections to those? Because we know it's all hearsay, but if we also know it's clearly covered by an exception, maybe we should not make those objections.
Your Honor, the state's more than happy to meet with any defense counsel, or we can talk after court, or they can email me and we can, before tomorrow, at least speak with one another and hopefully come to some agreement.
I mean, that would be great if y'all could at least try. And certainly there were a couple where, okay, this is not sure. Is this something based on the CAD that an officer's saying, or is this what the caller's saying? Those are legitimate. But I mean, a caller calling 20 seconds after a shooting saying, here I am, and I just woke up to hear all these shots. That's coming in, because there is a clear hearsay exception to that. So just see what y'all can do on that. And if you feel the need to go ahead and put forth the objection to each of them, then that's fine. We'll go through it. But, I know everybody's talking about how long this case has taken, and we could cut it a little bit shorter if we didn't do things like that. So I will let y'all talk about those over the evening. And we will circle back on Ms. Latner. So does that cover everything that was in the counts 3 through 7 folder?
Yes, Your Honor.
All right. All right, where should we move to next?
We can go through counts 14 through 23.
Okay. All right, does everybody have that one open? Okay, we'll just go in order.
One second.
Okay, no problem.
Just waiting for it to it's
Sure.
buffering. Okay, Judge, we're ready.
Okay.
The first folder doesn't have anything in there, Your Honor.
All right. Are y'all ready, Ms. Westmoreland? Are you still? Okay, so we are now looking at the counts 14 through 23 folder. All right, and we're moving to item 45 in there, or the one labeled 45. Okay. And that is an audio call between certain people.
Yes, Your Honor. So this is a jail call that we litigated last 45 Tiana Stanley. 45 Tiana, Tianna Stanley, Stanley.
Okay.
Your Honor, this is a jail call between the victim in this case, Gary Holloman, who is now deceased, a co-conspirator, Tinquarius Mender, and Tinquarius Mender's mother, Tiana Stanley. We did litigate this, I believe, in October of last year, and it was admitted based upon that litigation.
Okay. Anything else on that?
Your Honor, it was, just for the record, the court admitted it under 807 residual hearsay exception,
Interesting.
and it was admitted over our objection, my objection. This was a jail call, and the deceased was having a came on to the call at the behest of the inmate and the inmate's mother, Ms. Stanley. And that person came onto the call, had a conversation on a recorded jail call. And our position was that there was no establishment that the deceased, Mr. Holloman, had a very close relationship with either Tiana Stanley or with the inmate. And we objected on that basis. We did not believe that a jail call was a trusted conversation, that it was done on a public recording that was subject to a public airing, and that there was no establishment by the government that there was this trusted, close relationship that is typically required in an 807 setting, and that and for those reasons, as the court is aware, 807 residual hearsay is like the Hail Mary of letting evidence in when there's no other recourse, no other way that it can come in, so forth and so on.
And it happens sometimes when people die. All right, is there an order that I can look at?
Yes, Your Honor.
So this has not come in to the trial itself at all yet, is that
not
right?
come in.
Okay.
It has not, and there is an order, Your Honor, and we can forward that to you.
And also, Your Honor, just from the standpoint of Mender, who's on this indictment as well.
Okay.
So we would argue that, well, it was admitted under the 807 exception to the hearsay. We obviously don't believe that it would be anything that would come in under any type of co-conspirator theory or anything of that nature as it relates to Mender, who is on the indictment. It's not furthering any conspiracy or anything of that nature. If the state were saying, hey, it should come in because Mender's a co-conspirator or something of that nature. So it only came in under the 807 basis.
All right, was that an argument that was made and addressed?
No, Your Honor, we addressed it solely under residual hearsay.
Okay, well, if y'all can, if you want to just like, let me know the date of the order, y'all gave me that binder full of motions and orders, so I can find it not during court time. I can do that this evening and let y'all know.
And I'll tell you, Your Honor, the order, because there were several things we argued during that hearing. There was a 911 call, there was a body cam video, and it was this jail call, Your Honor. And the court excluded the body cam video. And I believe the order primarily addresses the body cam video and not necessarily the 911 and this jail call.
Do I then need to look at the transcript?
Yes.
Okay. Do you know what date that was?
It was November, I think it was November 3rd, but I'll pull it up just so I make sure.
All right, well, we'll come back to that one. November 3rd of 23. Okay. Okay. All right. And do you know whether that transcript's been filed? I can always check with Miss, I'm blanking on her last name, Christina Weaver. Okay, it's fine. I'll just check with her. All right, so let's just move to the next folder, I guess. So Officer Kornbacher or Kornbacher? Nothing, okay. Sergeant Henderson?
Your Honor, Sergeant Henderson was the detective on this particular case with
Okay.
respect to these acts. And the court has excluded his participation with respect. He had two primary roles with respect to these particular acts. One was to do the photographic lineup. And
Right,
the
and
other was to
that's-
conduct
can't
the
be in,
interviews.
yeah.
So I think that subject to that ruling are in this particular folder are basically
All right,
photographs.
let me just ask the state, what all do you intend to use from this folder?
I'm Donald J. Trump, and I approve this message. This is America's border czar, and she's failed us. Under Harris.
Don't think at this time we're going to use it, but we did just place it in here as an abundance if we decide to. I don't think we're going to be using his statement. And the MP4 is, and it should not come up, but the MP4 is I guess on iPhones, I'm not an iPhone user. They have, you can scroll the text messages and see all the text messages. And so the last MP4 were text messages between our victim in the case and the detective, because our victim lived out of town. And so he was communicating with the detective about the robbery and providing information to him via this chat. So potentially can come in as impeachment depending on what happens with my victim. If my victim says something inconsistent.
This is not the dead victim, this is
No,
a different
sorry.
victim.
Sorry, totally different victim. I apologize.
This is not Mr. Holloman, this is
Mr. Maynard. No, this is Mr. Maynard. This
Maynard.
shouldn't be in this folder. This actually should have been in another folder.
All right, so. Okay.
This video is from the 2019 armed robbery.
Okay, it's just in the wrong folder, but that victim is going to come testify and you might need to use the text as impeachment. Okay.
And I should also be clear, Sergeant Henderson ironically was the lead detective on both the 2019 armed robbery and the 2020 armed robbery.
All right, so is there anything in this folder that y'all intend to use? I mean, obviously that is just accidentally in there and you'll use it as to a different topic, but how about with regard to the, I guess, armed robbery of Holloman?
No, there's nothing in this folder that we intend to use.
All right. Thank you. All right, so then we've got Investigator Belknap. That folder's empty.
Yes, Sharon, and I just realized when Mr. Huey was arrested for the October armed robbery initially, there were items found at Mr. Huey's apartment that belonged to an individual by the name of Chandler Durham. I do not see those photos in here, so I need to add them, but they're in discovery.
Might be in a different folder.
They have been served. I see the videos in some other folders, but I'll make sure that what we intend to bring in through Investigator Belknap is placed in this folder.
And that was a search that was not, I mean, that
It was a search.
items can come in.
Yes, and Your Honor, it becomes relevant because in one of our acts, which is act number 102, we have alleged as an overact a text message between Mr. Williams and Mr. Huey, where Mr. Williams demands Mr. Huey to take his shit back. And his that he is talking about is Chandler Durham. And so all of that becomes relevant.
So we'll make I'm sure the court will anticipate certain objections at that time. Again, there are a lot of assumptions that are being made with respect to what it meant in the context of it, which I don't believe a detective is going to be able to, other than speculate, be able to know precisely. So we'll deal with it.
Okay.
And I don't believe Mr. Chandler Durham is on the state's witness list. I don't believe.
He was on our original witness list, but in an effort to cut down on witnesses, he's not on the reduced witness list. He is not.
Okay. So I assume there'll be something that establishes that these were his items?
Yes, Your Honor. Yes, we have pictures of items similar to what was found. We have pictures of Chandler Durham with items that were found. Yes, and we also have the 911 call from the Chandler Durham armed robbery.
Where he says, these are the items that just got stolen from me.
He talks about being robbed. I don't know if he says it on the 911
Well,
call.
y'all, I mean, I don't know if you might need to put him back on your list, because think about, what they're gonna hold you to your proof on everything. So
Yes.
there's gonna be an objection if you don't have a way to establish that the items found in the search of Mr. Huey's home are in fact the items that were stolen from Mr. Durham.
Yes, we're working through. I think we have worked through it that we could get around it, but
Well, we'll see.
we're working through it.
Okay. I don't know. All right. Investigator Flores.
Your Honor, based on your ruling, the next two folders, based on your ruling yesterday regarding the fleeing and attempting to elude, 49 and 50, we don't have to look into.
Okay. And then Bernie, is this anything that's different from what we looked at before?
Yes, Your Honor, we had Mr.
This is his second, more recent work he did? Okay.
No. So Agent Bernie, for several of the cases, analyzed phone records.
Okay.
So he just analyzed Mr. Huey's phone records relating to the October 1st, 2020 armed robbery.
Okay. Any issues about anything in that folder? Mr. Matthews?
We're good. No objection.
Okay. Thank you.
Yes.
All right, so that takes us to the end of the 31 through 60 folder.
No, I think.
No, I'm sorry, looking at the wrong thing. What was that?
So the next one we have, Your Honor, is counts 27 through 29.
Right, that was within the 31 through 60, that was 14 through 23. Okay. So now counts. What'd you say was?
27 through 29.
Okay. All right, we've got several items in the Smith folder. Anybody want to voice objection to any of those items?
Your Honor,
Yes, sir.
I'm having a tough time seeing which video I'm talking about, but I do know from my review of the discovery regarding this act, there is a FaceTime live or some sort of live stream of Mr. Beebe smoking marijuana, talking, saying absurd things. And I don't believe Mr. Beebe is going to testify. So I would object to I don't know what the relevance is of that. I know what the relevance is if he was on trial. He's wearing a chain that allegedly belonged to quote unquote trap commander, whose government name escapes me for the moment, but he was the alleged victim of this armed robbery, and he was the person with the chain. But I think a still shot from that
Okay.
live stream could serve the state's needs in that respect.
All right.
Robbery, we've alleged that two of the co-conspirators, Durante Beebe and Christian Eppinger, steal, armed rob Mr.
I'm sorry, say those names again.
Durante, Derontae, last name Beebe, Bebe, and Christian Eppinger.
Okay.
I
just didn't hear who you said next.
They
Go ahead.
they robbed Darius Smith in broad daylight at Cleveland Avenue Park. And some of the videos that we have are of Mr. Beebe and also sometimes Mr. Eppinger holding one of the items that they stole. And so these are some of the videos. We will go through and narrow down which
Okay.
of the videos that we will intend to use for.
Okay.
that.
All right. Well, let's, if y'all can do that tonight, and then we'll circle back on that tomorrow.
Your Honor, there is another video, and I know I've heard it, I've seen it, but when I was going back through this folder, I don't see it in here, where Mr. Eppinger is essentially bragging about the armed robbery. I'm going to look for it again, and then I will make sure everyone gets that video as well.
All right. And then next in this folder is the folder that is Adrian Ansart.
He's the custodian records for Instagram, and so it's just the Instagram return to his folder.
And then we've got Sergeant Pierre or Jean-Pierre.
Yes, Your Honor, he is the lead detective.
Okay. Assume that. So there, I see photographs. Would those be like crime scene-ish things?
Yes, Your Honor.
And then social media, is there anything we need to look at within that? Anything objectionable?
That will be some of the stuff we're going to reduce down tonight.
Okay.
Your Honor.
All right. We'll come back to that also. All right, and then the lineup ID. That I guess is there gonna be a victim to testify to that or?
Yes, the victim
Okay.
will be present, Your Honor.
All right. Then those oughta have already been dealt with if there were objections to them. Okay. So that's 27 through 29. Which should we move to next?
We can go in order, Your Honor, to 44 through 46.
Okay.
Which is the last set.
All right, we've got Deputy Timothy Brown.
And Your Honor, this is the possession of a weapon and cell phone of Mr. Huey and Mr. Mender, Your Honor. And so in here is just the body cam video of that search of that cell. And then we also have the jail records showing that both Mr. Huey and Mr. Mender were in the same cell together.
Who's the second name again?
Mender,
Oh,
Tinctorius
okay.
Mender.
Mender, all right. Any objections? All right. And then Vivarito.
Yes, Your Honor, that should primarily be the phone dumps or cell phone extractions for Mr. Huey.
Okay.
And then there is also a video visit with Mr. Huey, Mr. Williams, and Mr. Mender. And I just want to make sure that there are three, there should be 3 cell phone extractions.
Yeah.
So I just want to make sure there are 3. I see 2 of them, Your Honor, so I want to make sure there is a third one that was, no, I think all 3 are there. So there's the 1 of
Looks
2,
like it.
2 of 2, and then there's the third one.
Okay.
And then we have some screenshots, but there might be more screenshots that we'll provide.
All right, and then there appears to be another PowerPoint. I don't intend to use that, do you?
No, Your Honor, this was a PowerPoint that was used for grand jury, but
Okay.
it's something that we serve.
All right. And then I don't know what that last thing is in there. It's not a folder. It says iPhone 11 Pro Max.
I believe, Your Honor, that is the cell phone dump just in 2 places.
Okay.
I just want to confirm.
All right. So does that carry us through that whole, through witness number 60, or do I need to go back and?
It does, Your
Okay.
Honor. Some of our numbers are a little off just because we have a few different lists, but this is all the 60.
Okay.
And then we intend to provide the last group of individuals to the end, the last witnesses to the end on Monday. Your Honor.
Was that the deadline I gave you? Or did I give you a deadline?
I don't know if
for
you gave us
that?
a deadline for the last group, but we were doing it on Monday, so we just figured
Okay,
it's time for
That's
another
fine.
Monday.
all right, so that'll be 61-ish through the end of
Yes.
your witness list.
Yes, Your Honor.
All right, so then that would leave us tomorrow looking at these couple of things we set aside for today. And then, I mean, at some point we need to get to the wiretap stuff. So tomorrow then would be the day to do that because we have a free day tomorrow. We need to utilize it. Okay, so we'll break early today. but with the understanding that everybody needs to be ready to tackle the whatever is within the wiretap evidence tomorrow, as well as we'll circle back on the CAD reports after y'all have gotten a chance to get together, and then on the couple of things from that we just discussed that you might be able to narrow down. All right, anything anybody needs to bring up, put on the record before we adjourn for the day?
I can't think of anything from the state, Your Honor.
Okay,
Nothing on behalf of Mr. Williams.
all right. Yes, there is.
And I don't know if Mr. Adams can do this or we need to wait for Mr. Steele. Mr. Steele did provide to us the Dropbox link with some reciprocal discovery.
Mhm.
We know that there's some jail calls. There are a number of jail calls that Mr. Steele gave to us. If he could just narrow down which jail calls he intends to use. I believe this is with Mr. Copeland, so we can just know if we have any objections to
Okay.
it, but just the jail calls.
We'll go ahead and reach out. I know that Ms. Steele was working on that today.
Okay, well, great. Hopefully he can get that to the state by the end of the day.
I'll relay that. Yes.
Okay. Because obviously Copeland's cross is hopefully coming up before too much longer.
Oh, it's on the horizon, Your Honor.
So, yeah, that may be the first thing we need to take up tomorrow.
Can I inquire, Ms. Hilton? I know when we left off with Mr. Copeland last week, we were almost done, I think.
I mean, yeah, sounds like we've got a little bit more of that video still to get through, since we didn't really get anything done Friday afternoon because
A
of
jail
tech
call.
issues, but
A jail call, I think, if I remember correctly, Ms. Hilton.
Yes, the goal will be to pass Mr. Copeland, if not early afternoon. That is the goal, by early afternoon to pass Mr.
Okay.
Copeland.
Understood. Thank you.
all right. All right, doesn't sound like there's anything else, so I'll see y'all at 9 tomorrow. Thank you.
All right. So we got an early break today, and I am just going to do just a quick summary of the afternoon really quickly. Let's see here. And that is not the right one. So, all right. So court ends early today. I think it was a win-win for the state. The state got a lot of wins today. The only thing that was at the close was Quantavious. I think that's the pretty boy that Woody was speaking of, the one who liked the girls and that kind of thing. There's an armed robbery and some supposedly evidence about, another photo that may have a necklace that belonged to someone that's relative to him, but it wasn't really him. And a lot of evidence. The judge wasn't going to let that photo in, but the victim plans to testify. So that's going to be interesting because he could potentially be proven to be connected to YSL in the way that they're building this RICO. So that was pretty interesting. And tomorrow they're going to be doing wiretaps, and which is a good one, Copeland's cross. They're going to go through that. So Mr. Steele is in his office. That's what he's kind of working on today, the research and all of that. And they have supplied the jail phone calls from Kenneth Copeland. And so now the task is for them to have kind of like the specific pieces so that they can review it and see if they have any objections. So tomorrow should be interesting because they're going to iron out those, the cross for Kenneth Copeland. And as I've kind of seen in the theme of this, as Brian Steele or Sharpton, Sharp as they affectionately call him, as they kind of lead their ejections, then you see the other attorneys kind of piggybacking and coming in on more, more items, and that's relative to their client that can also help the client that they're arguing on. So I'm seeing a little bit of teamwork with the lawyers, but that's what they're going to be doing tomorrow. And they're going to be going over the wiretaps and seeing what's going to be admissible in that. And it's interesting to see who was wearing the wire. I'm willing to speculate it was probably Kenneth Copeland. Anywho, I'll be back later tonight to do a summary. Kind of like a recap of like the last 3 days, and focusing on the state's case mostly. So I'll be back later tonight at about 8:00, and I appreciate you joining me. And I'm going to enjoy this little early break. Thanks so much. Have a good one. It's your girl Duchess, and I'm out.